Welcome, everyone. The Subcommittee on Consumer Protection and Commerce will now come to order. Today we'll be holding a hearing entitled Transforming the FTC, the Federal Trade Commission, legislation to modernize consumer protection. Due to the COVID-19 public health emergency, members can participate in today's hearing either in person or remotely via online, via video conference. Members and witnesses who are participating in person, these are the new guidelines, must wear a mask. And members and witnesses who are not vaccinated must also be socially distant. Such members and witnesses may remove their masks when they are under recognition and speaking from a microphone. Staff and press who are present in the committee room must wear a mask at all times, and staff and press who are not vaccinated must be socially distant. Too bad that we had to move to different guidelines, I might say, but here we are. To be clear, mask wearing is now required regardless of vaccination status. For members participating remotely, your microphones will be set on mute for the purpose of eliminating inadvertent background noise. Members participating remotely will need to unmute yourselves and your microphones when you are each time that you wish to speak. Please note that once you unmask, once you unmute your microphone, anything that is said in WebEx will be heard over the loudspeaker in the committee room and subject to be heard by the live stream and C-SPAN. So, watch what you're saying into the microphone if you're not muted. Since members are participating from different locations at today's hearing, all recognition of members, such as for questions, will be in the order of the subcommittee seniority. Documents for the record can be sent to Ed Kosmarski at the email address that we have provided to staff. All documents will be entered into the record at the conclusion of the hearing. So the chair now recognizes herself for 5 minutes. Today we are considering 16 pieces of legislation intended to modernize the Federal Trade Commission's ability to pursue its consumer protection mission. For over 100 years, the FTC has been the premier federal consumer protection agency. But despite its broad mandate to protect consumers and to promote competition, the Commission has been sorely under-resourced for decades now. Today, it has a smaller staff and fewer resources than other consumer protection regulators. And however, it is a new era for the Federal Trade Commission now. In a breath of fresh air, the Commission held 2 open meetings this month. These public accessible meetings increase transparency and public input on important topics like the Made in USA rule and right to repair. It's time to recommit to restoring the culture and of the FTC to put consumers first. Many of the 16 bills that we are considering today will help them to accomplish this mission. These include the Online Consumer Protection Act, which I have introduced and with Representative Castor. This legislation will hold technology platforms accountable for failure to live up to the promises that they made with their made to consumers in their terms of service. The 21st Century FTC Act, sponsored by Representative Castor, and my own FTC Autonomy Act, will provide the Commission with additional enforcement tools, including rulemaking, civil penalties, and independent litigation authority. Legislation from our colleagues, Representative Rush and McNerney, will give the Commission authority over consumer protection violations by nonprofit organizations and telecommunications communications carriers. A few of the bills that are being considered today will allow the FTC to more efficiently police scams that target vulnerable groups. This includes bipartisan legislation from Representatives Rice and Upton focusing on fraud affecting military veterans and service members. And legislation from Representative Kelly would establish a task force to bolster the communications work, the Commission's work on equity issues, and would inform the public about scams targeted specifically to other groups. Representative McNerney has legislation that would create the Office of Technologists to provide additional technical assistance to the Commission and update in every technology consideration. Today, these bills will forge a new path forward for the Federal Trade Commission. I'm going to ask my ranking member for permission to go over time. As you can see, I do have some reading issues that are hampering me in some ways. It's a physical thing that I've got. Okay, thank you very much. So today, these bills will forge a new path forward for the Federal Trade Commission. They strengthen the Commission's consumer protection capacity and provide the tools necessary to guide today's increased innovation and dynamic marketplace. It is essential that the Commission have the tools it needs to hold technology platforms accountable. The era of self-regulation is over. Self-regulation has threatened our democracy and now threatened our health and our very lives as vaccine misinformation continues to spread across social media. Consent decrees and fines have proven ineffective in improving the behavior of technology companies. Violation after violation underscores that stronger enforcement enforcement tools are urgently needed. The American people deserve a 21st century consumer protection agency that meets 21st century threats. And I am looking forward to hearing from the witnesses that are here today on how modernizing the Federal Trade Commission and protecting consumers can happen. I want to say a special thank you to our witnesses. I'm so grateful to the commissioners who are all here today, 3 virtually and 2 in person. Thank you so much. And also from our experts that we will hear for the second panel. The chair, thanks for the indulgence. I'm practicing on how to use my new disability to speak more properly, but here we are. And the chairman now recognizes Mr. Bilirakis, the ranking member of our subcommittee, for 5 minutes.
Thank you so much, Madam Chair. I appreciate it. Thank you for holding this important hearing. And to both panels appearing today, we really appreciate it very much. I'd like to welcome all 5 of our FTC commissioners, I guess 3 virtually and 2 in person, in front of our subcommittee, where we can not only examine the legislation before us, but also conduct oversight of the commission. Chair Khan, congratulations on your recent confirmation as commissioner and chair of the FTC. This is a very important agency, as you know, and I am eager to learn how you will continue leading on its important work, especially in the protection of our constituents from fraud and scams, and how you can enforce a national privacy standard we want to enact. It is critical we get the ball rolling on that effort. I'm also interested in learning how the FTC can assist with protecting Americans from ransomware and other cyber attacks. I recently introduced H.R. 4551, the Ransomware Act, which would amend the Safe Web Act to focus on such attacks. The FTC can play an important role in securing our nation from ransomware. So I hope today's conversation may assist in fine-tuning my legislation to best accomplish this goal. Given the majority scheduled this as an oversight hearing as well, I would be remiss if I did not inquire about recent changes at the FTC. Chair Khan, I understand that change comes when a new team is in charge, and we will have our policy differences here in D.C., but that should not stop you from working with your fellow commissioners in a collegial manner. So you must understand why I'm concerned when we hear reports of individuals inside the FTC being silenced and your other commissioners being shut out of the process. We must take these allegations extremely seriously. It's concerning the recent changes in FTC processes took place without acknowledging the consideration of all commissioners and of FTC experts, some of whom have lifetimes of experience within the subject matter. To those staff, I hope you're watching today, so you may know this commission cares. Again, this committee definitely cares about the FTC process remaining open and transparent, and that your voice and expertise play an important role. We will begin a process to review these allegations, and with that, I would like to announce for the FTC staff listening that if you have any issues, we have created a whistleblower email. It's ecgop.whistleblower@mailhouse.gov. Again, ecgop.whistleblower@mailhouse.gov. As you're aware, with other bills on the docket, Republican members of this committee introduced legislation to ensure guardrails are included in any FTC decision-making process. I'm glad to see these bills are on the docket, and I appreciate it, Madam Chair, that you placed them on the docket. Thanks for following through. They will bring much-needed transparency, in my opinion, require proper notice and input from key experts at the FTC, like from the Bureau of Economics, something I wish was included in H.R. 2668, the legislation that expands Section 13B. As I have said before, Republicans support providing the FTC with the tools they need to pursue bad actors and to sufficiently enforce privacy standards. So I ask that the Democratic proposals in front of us be considered in that context. I hope my Democratic colleagues' engagement on these issues will also mean seriously engaging on putting in place a national privacy standard. Madam Chair, thank you again for holding this hearing. We have a lot to get through today, so I wanted to be as brief as I could. I'm eager to learn how we, as the Committee of Jurisdiction, can bring much needed transparency to the FTC and how the legislation before us may do just that. And I thank you very much. I yield back.
The gentleman yields back, and the chairman now recognizes Mr. Pallone, chairman of the full committee, for 5 minutes.
Thank you, Chairwoman Schakowsky. Today we're continuing this committee's important work on putting consumers first. For the past few months, the subcommittee and then the full committee pushed forward the Consumer Protection and Recovery Act to restore the FTC's basic authority to get stolen money back to consumers. That urgently needed legislation passed the House last week, and I urge the Senate to take up the bill without delay. With House passage of the Consumer Protection and Recovery Act, we must take the next step, not just fixing what was broken, but improving the nation's foremost consumer protection agency and putting consumers first. The FTC initially addressed only unfair competition, which led to unjust results for consumers. But then in 1938, Congress met the moment, enacting the FTC's now core Section 5 authority to enforce against unfair or deceptive acts or practices. By granting the power to stop consumer harms, the FTC's consumer protection mission was born at that time. And over time, the FTC needed more authority to execute its mission. In 1973, Congress met that moment by granting the FTC the authority to go into federal court and seek relief for consumers, including under Section 13B of the FTC Act. And these changes led to billions in relief for consumers and a more efficient way to deter illegal conduct. And the legislation that passed the House last week would restore this critical authority after it had been seriously undermined earlier this year by the Supreme Court. We are now facing another seminal moment for consumer protection. The digital age has fundamentally changed the consumer experience, but the FTC's mission to protect consumers and honest businesses remains the same. Congress must meet the moment again. It's time to bring the FTC into the modern era, to give it the tools and resources to keep up with changes in the market, and much of the legislation before us today would do just that. That legislation that would improve general rulemaking authority under the Administrative Procedure Act would remove uniquely onerous burdens so the FTC can more efficiently provide clear rules of the road to businesses and consumers. Legislative proposals would also give the FTC civil penalty authority, which is critical to impose meaningful consequences on wrongdoers and deter other bad actors. Those reforms help industry and individuals and are essential to maximize the FTC's limited resources. There's also legislation that ends exemptions on nonprofits and telecommunications common carriers from FTC jurisdiction that also helps consumers and businesses. Consumer protection enforcement should be based on the activity, not the entity. Unfortunately, on the other hand, some proposals before us today would hinder the FTC and ultimately harm consumers. I'm concerned by the proposals that would burden staff and drain resources with needless process and reports and effectively obstruct information exchanges between the FTC and other regulators and lawmakers. The bills that I'm talking about would undermine the FTC's ability to prevent potential harms or react to unusual, unfair, and deceptive practices. Some of these bills would hurt companies by potentially forcing the FTC to reveal confidential investigations before the FTC has determined whether illegal acts have taken place or whether it will take action against the subjects of the investigations. And I believe these proposals will put the FTC on the wrong track. Now, my Republican committee colleagues have routinely emphasized the need for comprehensive consumer privacy legislation, and I agree, and that's why the committee remains hard at work on privacy. But at the same time, their legislation would effectively gut the FTC's ability to protect consumer privacy, and I believe that across-the-board deregulation and a strong federal privacy regime cannot coexist. So I thank all 5 commissioners for appearing before us. I also look forward to hearing from our expert witnesses, and I yield the balance of my time to the gentlewoman from Florida, Ms. Castor.
Well, thank you, Chair Pallone. This is a critical hearing because the Federal Trade Commission is absolutely vital to protecting our neighbors back home, protecting consumers, and then fostering competition across the economy. And we have got to give the FTC all of the tools it needs to help protect consumers from fraudsters and scam artists, predatory companies. My neighbors back home in Florida, which is rife with, unfortunately, with scam artists, they really need the FTC at work at full force. They have got the FTC. A lot of folks don't really understand. You all help recoup money. You help hold these fly-by-night operations accountable. You, in essence, restore the dignity to folks who have been scammed, and you penalize these bad actors. So, welcome, Chair Khan. Welcome, commissioners. We look forward to working with you. I'd look forward to hearing you today along with our expert panel. And I really appreciate Chair Schakowsky, you including my 21st Century FTC Act in this hearing today. So thank you. I yield back my time.
The gentleman has yielded back his time. And now let me recognize Ms. Rogers, the ranking member of the full committee, for her 5 minutes for an opening statement.
Thank you, Madam Chair. Welcome, Chair Khan, our distinguished members of the Federal Trade Commission, as well as our second panel of experts. This past year has been difficult. COVID-19 has not only altered our daily lives, it's refocused the way we conduct our business in Congress. Over the past year, it's been essential that we work together in a bipartisan way to protect seniors and other vulnerable populations. Thanks to our work with Chair Schakowsky, we've been able to expand the FTC's authority to go after COVID-19 fraudsters and scammers. Yet, I'm concerned today that we are now prioritizing politics over protecting Americans. Just last week, we saw a very partisan 13B legislation narrowly pass the House floor. What makes this worse is that just a couple of weeks prior, during a committee markup, Representative Bill Rackus introduced an amendment to this bill that received bipartisan support, but it was shut out by the majority once the bill moved to the floor. A colloquy on the House floor between committee Democrats tried to clarify the intent of the underlying bill. The concerns raised during the colloquy would have been clearly addressed by Bill Rackus's compromise. This begs the question, if our compromise amendment was considered on the floor, would it have passed? I believe that the answer is yes. Sadly, the partisan process for 13B was also a missed opportunity to enact national federal privacy standard, something we desperately need to ensure that people's personal information is protected online. America's data and personal information does not end with state lines. Neither should privacy protections. Considering proposals on the agenda today were part of the bipartisan privacy negotiations last Congress. I'll be listening for ways that these bills being considered can be adapted into a national privacy standard, which would be a landmark achievement for this committee and for the protection of America's data. I certainly hope they don't move alone, as standalones. In the past, even when we disagreed on certain approaches to policy making, we were able to come together and work in a bipartisan manner. This was the case when Chairman Pallone led on attacking robocalls and enacted the landmark TRACED Act. That was Congress at its best, and I hope that we return to that, because what we have now is a set of really bad examples for agencies and departments under our oversight. We've heard reports on shifts at the FTC to shorten notice of actions, limit consultation, and reduce economic analysis. This trend is crippling the thoughtful process at the FTC and jeopardizing fraud protections for Americans who need them. It's a disservice to Americans. Your mission is to protect. By neglecting your duty to follow a process that allows for proper deliberation and input, input from experts, it is a disservice. I implore you to resist the urge to take your focus off of consumer protections. Engage with the public to find out what alarms them most. Listen to people at regional workshops about their top concerns. I'd be surprised if you didn't hear stories about unwanted calls for scam real estate leads, car warranties, even fake IRS bills. These are the kinds of things that should guide your efforts. The FTC is an independent agency that should not have your agenda dictated by the White House. The time to establish a strong and uniform data protection for all Americans is now. I look forward to hearing from you. I yield back, Madam Chair.
The gentlelady yields back. The chair would like to remind members that pursuant to committee rules, all members' written opening statements shall be made part of the record. I now would like to introduce our witnesses for our first panel at today's hearing. The Honorable Lina Khan, Chairman of the Federal Trade Commission. The Honorable Noah, we have them on, okay. The Honorable Noah Joshua Phillips, Commissioner at the Federal Trade Commission. The Honorable Rohit Chopra, Commissioner, the FTC. The Honorable Rebecca Slaughter, Commissioner at the FTC, and the Honorable Christina Wilson. I'm sorry, it's Christine, excuse me. Wilson, the Commissioner at the FTC. At this time, the chair will recognize each witness for 5 minutes to provide their opening statement. Before I do, I think most of you are already familiar with the lights, but let me explain that system. In front of our witnesses is a series of lights. The lights will initially be green. The light will turn yellow when there's 1 minute left. And please begin to wrap up at that point. The light will turn red when the 5 minutes have expired. So, Chair Khan, it is a pleasure to welcome you and to recognize you for 5 minutes.
Thanks so much. Chair Schakowsky, Ranking Member Bilirakis, and members of the subcommittee, I am pleased to appear before you today to discuss the 16 bills under consideration by the subcommittee. Thank you for this important work, and I look forward to working with you all. My testimony today will identify several key issues currently facing the Commission and share initial views on some of the bills currently being considered. Congress created the Federal Trade Commission to serve as a guardian for fair competition and to protect consumers, workers, and honest businesses from unfair or deceptive trade practices. This statutory charge has never been more important, yet the Commission faces today notable challenges in carrying out its mission. I'll briefly describe 3 problems that are currently shaping the agency's work. First, as this subcommittee is well aware, the Supreme Court's decision last year in AMG dealt a serious blow to the FTC's ability to seek refunds for defrauded victims and to disgorge ill-gotten gains. Across the Commission's work, the loss of Section 13B is leading to windfalls for lawbreakers. For example, after a major pharmaceutical company engaged in a multi-year scheme to keep drug prices high by choking off generics, a court ordered it to return $448 million to victims. The Supreme Court's interpretation of Section 13B has meant that the pharmaceutical company was later instead allowed to pocket these illegal profits. Altogether, AMG has jeopardized over $2 billion in potential relief to victims in pending cases. Beyond monetary relief, the FTC now also faces challenges in seeking an injunction to halt wrongdoing, curtailing the Commission's ability to challenge past abuses. I'm committed to using the full range of the FTC's tools to crack down on unlawful conduct. But restoring our full Section 13B authority is critical, and I'm grateful that the full House has already acted on Congressman Cardenas's bill to rearm the Commission against these growing threats. Second, Americans have been subjected to a massive increase in fraud over the last year, with the number of complaints up more than 20%. While the FTC has focused on shutting down COVID-related schemes, from bogus treatments to government imposters, fraud has continued to surge. One reason is that fraud today is supercharged by digital platforms where this conduct is tolerated and even promoted by some of the world's largest companies. Business models singularly focused on scale and engagement, coupled with micro-targeting, have allowed these platforms to become finely tuned instruments for bad actors who often target the most vulnerable. Although digital platforms profit off of the tools that are being weaponized against Americans, these companies often claim special immunity under the law. The Commission will continue to aggressively pursue those that exploit this crisis to target American families. But ultimately, systematically rooting out fraudulent schemes will require focusing on the warped incentives and legal privileges that allow major firms to profit from predation. Third, even as the agency tackles the proliferation of unfair or deceptive practices, the current merger boom threatens to make them worse. Significant market consolidation deprives consumers, workers, and independent businesses of choice, further enabling dominant firms to engage in unfair practices. As the wave of privacy abuses in recent years has shown, market dominance often allows companies to renege on commitments, evade the law, and repeatedly violate commission orders. We are seeing rapid consolidation across industries. Through the first 3 quarters of this fiscal year, antitrust agencies have processed over 2,400 merger filings, a level of activity that is already the highest in 2 decades. Although the FTC is working to review many of these deals, the sheer volume of transactions is significantly straining commission resources. I am deeply concerned that the current merger boom will further exacerbate deep asymmetries of power across our economy, further enabling abuses. This subcommittee is considering several bills that would boost the Commission's ability to confront these challenges. Both the FTC Autonomy Act and the 21st Century FTC Act would help the Commission seek civil penalties against lawbreakers. This would mark an important change, guaranteeing the public greater protections. Bills that would end special protections for select industries would also strengthen our law enforcement. For example, the Online Consumer Protection Act would clarify that platforms cannot claim special privileges when facing an FTC enforcement action. Meanwhile, the Protecting Consumers in Commerce Act and Removing Nonprofit Exemption Act would allow the FTC to challenge abuses by common carriers and nonprofit entities. Finally, several bills focused efforts on communities that are often particular targets of predation, including older Americans, service members, and consumers. These bills are a critical reminder of the importance of the FTC's work in ensuring that our government works for all Americans. I look forward to working with the subcommittee to meet the challenges that we face, and I welcome the opportunity to answer any questions.
Thank you very much. And now, Commissioner Phillips, you are recognized for 5 minutes.
Thank you, Madam Chair. Chair Schakowsky, Ranking Member Bilirakis, members of the subcommittee, thank you for the opportunity to appear before you. I'm honored to testify with my fellow commissioners about the important work we do at the FTC. I am glad the subcommittee has decided to solicit a range of views on agency reform. I'd also like to take a moment to thank the staff at the Edgartown Public Library for providing me with a private, quiet place to testify. I will be masked in adherence to library policy. The thoughtful proposals members have made on agency reform deserve attention, in particular those designed to increase transparency into the Commission, like the FTC Reports Act, sponsored by Congressman Bilirakis, and Mr. Guthrie's FTC Transparency Act. In the last few weeks, the Commission has repeatedly changed policy direction without giving the public any real notice or right to be heard, and without serious consideration, removed guidance from the public and business community alike. And by removing Commission oversight from antitrust and other investigations, as we recently did, we have reduced transparency within the agency. We must do better. As you consider agency reforms, I urge you to think about the other ways in which the agency is changing course. The first change is the Commission pivoting, without Congress, to regulate a great deal of the economy. Over the last few years, my colleagues have called for a bevy of new rules, mostly under authorities that we have. The President's recent executive order contemplates our issuing major regulations concerning, among other things, pharmaceuticals, technology, labor, retail, and devices. Not all of the proposals in the executive order are bad, to be clear, but much of it would replace consumer-driven market forces with government-supervised regulation, the opposite of competition. And much of that appears to be based on authority we simply do not possess. The Commission, however, is in a hurry to regulate. For example, on July 1st, without input from the public, we adopted rules to enable us to promulgate regulations with less objectivity, less oversight, and less public input. The Commission majority is reducing what it calls red tape on the Commission to impose more real red tape on American businesses, large and small. Well-crafted regulations can help consumers and businesses, but poor regulatory design can raise prices, stifle innovation, and reduce consumer choice. This was a lesson America learned the hard way decades ago. And when it comes to policy questions of great economic and political importance, my basic philosophy is that Congress, not the FTC, is the place to answer them. I believe the law reflects that fact. Privacy is a good example, and I commend Committee Ranking Member Rogers and Subcommittee Ranking Member Bilirakis on their recent letter calling for privacy legislation and for the administration to make it a priority. In adopting regulations, I hope we address clearly defined problems, fashion rules designed to address them, and minimize unintended consequences. I hope we base our decisions on empirical evidence and input from all stakeholders, which is why I also support the goals of the RECS Act, introduced by Congressman Bouchon, to ensure that we approach Congress with analytical rigor. Another change I fear is moving away from the Commission's historical commitment to combating fraud. Just a few weeks ago, this subcommittee considered amendments to Section 13B, following the Supreme Court's AMG decision. As we detailed in testimony, the fraud program has for decades done essential work to return money to victims of fraud. Companies, large and small, that engage in fraud can cost consumers their life savings. In the past 5 years, we've returned $11.2 billion in refunds to consumers who are victims of fraud. I'm heartened that Congress has appropriated funds and passed laws to strengthen the fraud program. And count me among those who believe that a well-crafted amendment to 13B with guardrails will help serve consumers. Of late, some of my colleagues have made comments to suggest that we should focus only on large companies. The fact is that many of the frauds we see are not perpetrated by those kinds of companies. And I hope these comments do not indicate a desire to turn away from the fraud program. Where big corporations violate the law, we absolutely should hold them to account. But some of the wrongdoers that hurt Americans the most happen not to be large corporations. We should focus on harm to consumers, not the identities of defendants. While enforcement against robocallers, COVID-19 scammers, and others may not generate as many headlines, it generates results for consumers. While Section 19 is not a perfect tool, it enables us to return money to them. We should continue to commit resources to combating practices like fraud that cause the most harm. And I welcome legislation like updating 13B that will help with that. Thank you, and I look forward to your questions.
Thank you. Now, Commissioner Chopra, you are recognized for 5 minutes.
Chair Chakowski, Ranking Member Bilirakis, and members of the subcommittee, thank you for holding this hearing today. My name is Rohit Chopra, and it's an honor to be here with you and my fellow commissioners. The pandemic created the conditions for a wide range of market abuses that harmed so many Americans, including millions of small businesses. Many small businesses in America didn't just find their financial futures in peril, they also found themselves completely under siege by unfair, deceptive, and anti-competitive practices by dominant firms. Local restaurant owners were worried about food delivery apps that coerced them into paying extraordinary fees. Local franchisees faced new onerous requirements that franchisors were imposing on them, even as they struggled to stay afloat. Independent pharmacists, who played a critical role in the response to the pandemic, found themselves at the mercy of middlemen, using tactics that are driving many of these independent clinics out of business. And the same goes with small retailers and small banks, and the list goes on and on and on. It was crystal clear that small businesses across the country needed the FTC's help, but many felt completely ignored. I appreciate your work to increase the effectiveness of the Federal Trade Commission. And as you pursue these efforts, I would also encourage you to consider other reforms to ensure that the FTC is more responsive to small businesses and less slanted in the favor of larger ones. We need to look at laws related to ethics and financial conflicts of interest and more. Small businesses have expressed concern that the FTC routinely gives favorable treatment to large, powerful firms such as big tech and big pharma giants, while ignoring pleas for action to address practices harming small players. When big tech companies egregiously violate privacy and the law, the FTC has shown across multiple administrations that it is more than willing to be lax and forgiving. But when small businesses violate these laws, the FTC brings down the hammer on them, wiping out revenues and often shutting them down. This two-tier approach does not make sense. Congress should explore whether our laws need to be amended to reduce favoritism toward these dominant players, crack down on financial conflicts of interest, and increase responsiveness to local businesses and upstarts. First, Congress should examine whether to revisit laws regarding post-employment restrictions for senior FTC officials. While senior officials cannot immediately represent clients in front of the agency, many are able to work quietly behind the scenes, leveraging their intimate knowledge of non-public agency deliberations on law and policy. This gives them an enormous advantage on how to help large firms escape meaningful accountability when they break the law, and how to advise them on how to get the FTC to take specific actions. Small businesses don't have the resources or the ability to hire former FTC commissioners and bureau directors who regularly appear before the agency on behalf of dominant firms. This creates an unlevel playing field for small businesses engaging with the FTC seeking action or a fair resolution. Congress should also assess whether existing post-employment restrictions and other standards regarding financial conflicts of interest in our laws are adequate. While some argue that tougher restrictions will deter some from considering government service, our experience at the FTC reveals a different story, with many of our most talented officials devoting the vast majority of their career to working in public service. In addition, Congress should also determine whether existing law regarding so-called sponsored travel needs to be updated. Under existing law, senior government officials can be sponsored by non-federal sources to travel to conferences and retreats largely attended by and indirectly paid for by those representing dominant firms, especially big tech. These events sometimes include closed-door panel discussions that are not open to the media or the public, giving conference organizers and their patrons a chance to gather intelligence about emerging policies and priorities. This non-public information can be exploited by investment funds that trade on this information. Small businesses and the general public can't easily access these private panel junkets and don't have the resources to organize them on their own. To ensure equal access and fairness, it will be important to examine whether laws and regulations need to be amended to guard against real or perceived conflicts of interest when it comes to sponsored travel by non-federal sources. In closing, it is clear that honest businesses need the FTC more than ever. I am confident that we can work together to fairly administer the law and promote a marketplace free of fraud and anti-competitive abuses. Thank you, and I look forward to your questions.
Thank you, Commissioner. And now I recognize Commissioner Slaughter for 5 minutes for an opening statement.
Thank you, Chair Schakowsky, Ranking Member Bilirakis, and members of this subcommittee. I'm pleased to appear before you today, and I appreciate the opportunity to appear remotely. With 4 children too young to be vaccinated at home, I am being extra cautious about COVID exposure. I want to start by thanking this committee for its incredibly hard work to pass the Consumer Protection and Recovery Act, what we refer to as the 13B fix, through the House earlier this month. I'm grateful for your appreciation of the challenges the recent Supreme Court decision posed for the Commission, for your hard work to arm us with the tools we need to protect your constituents. I'm eager for us to continue to partner with Congress and this committee. While I'm happy to discuss the bills before the committee today, I also want to encourage you to continue work on a meaningful, comprehensive legislative approach to data abuses. Yesterday, the FTC held its 6th annual PrivacyCon conference, with presenters covering topics including algorithmic bias, issues around consent, misinformation during the pandemic, and special concerns related to kids and teens. That broad agenda reflected our understanding that data issues have moved past the narrow framework of who has access to your personal data. This understanding is why I prefer the term data abuses to the narrower language of privacy. Thinking in terms of abuses reflects the fact that rampant data collection, sharing, and exploitation harms consumers and competition in ways that affect nearly every aspect of our lives. I know this topic is front of mind for members of this committee and that you are actively considering how best to craft legislation to directly address the harms faced by consumers, workers, and small businesses in our data-driven economy. I also understand that doing this well takes time and thought, and encourage you to focus on approaches that not only address the full panoply of harms that stem from indiscriminate data collection, including civil rights violations, abuse of market power, economic exclusion, and exploitation of children, but also provide meaningful solutions that root out damaging and dangerous business models and market practices. When it comes to questions about personal data, I respectfully suggest we move past outdated notice and consent models that put untenable burdens on users. Instead, we should turn our focus to changing the underlying incentives that fuel data-driven business models, such as behavioral advertising. One approach to consider is data minimization, a principle that would ensure companies can collect only the information necessary to provide consumers with the service on offer and use the data they collect only to provide that service. That minimization could be coupled with further use, purpose, sharing, and security requirements to ensure that the information companies collect isn't used to build tools or services that imperil people's civil rights, economic opportunities, and personal autonomy, or facilitate corporate self-dealing. We have to recognize that as long as key digital markets are controlled by just a few large data-hungry online platforms, both consumers and prospective entrants are at their mercy. As Congress continues to debate these issues, I believe it is incumbent upon the Commission to act within the full scope of our existing authority to target pernicious data practices with both aggressive enforcement and rulemaking. A quick note about rulemaking, which I know can generate big reactions. Congress specifically delegated to the FTC the authority, albeit with a burdensome process, to write rules that prohibit or regulate any unfair or deceptive act or practice that is prevalent in interstate commerce. In other words, if we can already sue someone for committing an unfair or deceptive practice in violation of Section 5 of the FTC Act, and that practice is prevalent, then we can also write a rule that clarifies for the markets that the conduct is prohibited. That means rulemaking can only target conduct that is already illegal. Rules are developed using a participatory process with substantial stakeholder engagement, and when finalized, provide notice and certainty to the markets about what conduct is outside the scope of our 100-year-old statute. As I've said before, I believe it is past time for the FTC to begin a rulemaking process on data abuses. Among other benefits, this process can have a clarifying effect for the congressional debate as well. Participating in the rulemaking process means businesses, advocates, consumers, workers, researchers, and other interested parties will all have the opportunity to make their opinions known, out in the open, and with specificity in the public record. An open record can provide substantiation of the types of consumer protection and competition harms people are experiencing in digital markets and illuminate how we can act decisively to stamp out these abuses. I look forward to working with my fellow commissioners and with Congress to advance these efforts, and I welcome your questions.
Thank you. And Commissioner Wilson, you are now recognized.
Thank you. Chairman Pallone, Ranking Member McMorris-Rodgers, Chair Schakowsky, Ranking Member Bilirakis, and distinguished members of the subcommittee, thank you for the opportunity to testify. In my remarks, I will address Section 13B, federal privacy legislation, and process issues that have arisen recently at the Commission because those process issues impact my view of the 16 bills we will discuss today. I am blessed to be serving my third stint at the Federal Trade Commission. I have great respect for the agency's devoted personnel, and I remain amazed at how much we accomplish in so many different industry sectors despite our small budget. And I am proud of our agency's history of collegiality and bipartisanship. I understand that elections have consequences. The Biden administration may choose to pursue different policies than its predecessors, but the process used to implement those changes matters. Congressman Pallone stated in 2016 during a hearing on FTC legislation, "I am a big proponent of regular order. That means engaging in real deliberation, not just checking the boxes." I agree with that sentiment, and I believe it applies equally to the Federal Trade Commission. As a political appointee nominated by the White House and confirmed by the Senate, I am obligated to exercise due oversight of Commission business. FTC actions traditionally have been the product of robust dialogue and analysis supported by briefings and staff memoranda. These procedures facilitate a healthy flow of information among commissioners and staff and enable us to arrive at reasoned conclusions. When we adhere to these traditions, I am able to fulfill my oversight function. But in recent weeks, longstanding norms and procedures have been jettisoned. Practitioners, academics, and former enforcers across the political spectrum have expressed concern about the agency's abrupt departure from regular order. I share these concerns, and they impact my view of the bills we will discuss today. Some bills establish additional procedural safeguards and augmented oversight. Given the shift away from regular order, those bills are more important now than ever. Other bills give the FTC additional authority. Given the FTC's conduct in the 1970s, I have long been concerned about the possibility of agency overreach, and recent actions by Commission leadership have deepened those concerns. I am wary of more power without appropriate guardrails. Turning to Section 13B, I appreciate this committee's attention to this issue. I support Commission authority to seek equitable monetary relief in appropriate cases and to challenge conduct that wrongdoers have halted. But I understand the concerns that have been raised. Some are concerned about disgorgement in antitrust cases. Guiding principles on when the FTC will seek disgorgement, like those in the FTC's 2003 disgorgement policy statement, would provide appropriate guardrails. Others are concerned about using 13B in consumer protection cases that involve not fraud, but legitimate companies selling legitimate products, albeit with deceptive claims. Congress can include a framework in 13B under which courts must evaluate the value consumers have retained from the product or service despite the deception. The bottom line, with proper guardrails, legitimate concerns can be addressed while also enabling the FTC to pursue wrongdoers in appropriate cases. And finally, I'd like to address federal privacy legislation. Businesses need clarity regarding the rules of the road in this important area, but more importantly, consumers need clarity regarding how their data is collected, shared, and monetized. Without this information, consumers cannot make informed choices about the costs and benefits of using various websites, apps, and devices. The events of the last 18 months have exacerbated privacy concerns, but they have also underscored that our civil liberties, including Fourth Amendment protections, are at stake, and the FTC's existing jurisdiction and tools are limited. I thank the members of this committee, in particular Ranking Member McMorris-Rodgers and Ranking Member Bilirakis, for their recognition of this important issue, and I encourage the committee to continue working on privacy legislation. As the elected representatives of the American people, you are best situated to make the important value judgments inherent in privacy legislation. President Biden's recent EO asked the FTC to consider a privacy rulemaking. I recently had become more receptive to a privacy rulemaking as a stopgap measure until Congress could act, but the Commission recently voted along party lines to erase procedural safeguards and limit opportunities for public input during our rulemakings. Consequently, I am now much less receptive to an FTC rulemaking. Federal privacy legislation remains the optimal solution, so I encourage you to act. In closing, I thank this committee for your time and support of the FTC's mission. I'm happy to answer any questions you may have.
Thank you. We have concluded witnesses' opening statements, and at this time, we will move to. I'm sorry.
Vote on a motion to adjourn.
Oh, I'm sorry. There's a vote on the floor, so we are going to recess How many votes are there? Just one. Can we have people just go? Do we have to recess? Do we have to recess? Or can we have people just go out? So you think we should recess? I think so. Okay. Yeah, since the time of voting actually has gotten pretty strict, we're going to recess, but come back as soon as you can so that we can get to our question period. And I not exactly apologize to the witnesses. This is our life here, but we will be back as soon as we can to get to questions. Thank you. So we're another distracting vote right now. We're going to have to just run and come back. I really appreciate your patience. If you can stay, please do. Please do. We have so much to do yet. All right. Okay, we're going to come back to order. Thank you, and once again, these are situations beyond our control, and I appreciate your patience. So we are going to begin with the questions from our members, and I want to begin with 5 minutes of questioning. I want to talk about holding big tech accountability and online consumer protection, et cetera. There's no doubt that, especially during this pandemic, that more and more Americans are increasingly online, and the importance of holding the technology companies accountable is more and more important, I believe. And there's absolutely no reason for internet platforms to not hold to the same accountability standards as for harming consumers as offline businesses. What is illegal offline ought to be, in my view, illegal online as well. So let me start with you, Chair Khan. I am going to assume that you believe that the FTC can do more to protect consumers from online harms, right?
Yes, Congresswoman.
Thank you. In your view, is it unfair or deceptive when social media platforms or online platforms fail to follow their own terms of service?
Chairwoman, I'd say as a general matter, there is a lot of concern around the opacity of their policies and procedures, and so sometimes it can be difficult to know when they are or are not following their own policies because of that opacity, and so I think those information asymmetries can create a lot of problems.
So do you think that the FTC existing authorities sufficient to enforce against violations that we see to absolutely deter further violations?
Congressman, I think there is certainly more we could be doing under our existing authority. I do think that there are areas where the courts have scaled back our authority. There are cases where the platforms are able to claim particular privileges under the law that can create defenses that we have to then argue against. So I think there is room for more work, but there are certainly challenges as well.
Well, if you could talk a little bit about that, and I want to ask Commissioner Chopra the same thing. What are the kinds of things that you envision, and the other commissioners would be welcome after those two? Go ahead.
So I think some of the types of provisions that you've proposed, including civil penalty authority specifically for some of these types of being able to go after some of these types of practices, enabling other enforcers to also be enforcing some of these provisions like the state AGs. I think that could also help with deterrence. But overall, I think figuring out how we create some of that parity between online and offline is going to be very important.
Also, Commissioner Chopra, if you could also talk about resources, whether or not, even if you want to, what capabilities does the Commission have not having enough resources?
Yeah, I think this is a huge issue right now. Right now, we are facing a massive merger surge. It is stretching capacity to the limit, and the rubber band is snapping. And at the same time, in order to prosecute certain cases, we have to go up against well-financed defendants who can claim Section 230 immunity with impunity. They use it for almost every single thing when it comes to platform-related conduct. This immunity is abused, and Congress absolutely needs to fix it because it is an impediment to protecting consumers and small businesses online.
So, we've had bipartisan discussions about 230, and one of the bills that has been introduced also would begin to address the 230. I'm just wondering if any of the other commissioners, are you still here, by the way, would want to comment on what can and should the Commission be doing? to protect consumers and more efficiently?
I'm happy to jump in, Madam Chair, and thank you for the question. I want to echo comments that my colleagues have offered, and thank you for your leadership in calling attention to some of the problems that 230 in particular has posed for enforcement. I'm especially worried about the areas where 230 provides protection for platforms for illegal conduct and the way that they condone or facilitate illegal conduct on their platforms. I also think the resource question can't be overstated. Not only do we have to go into litigation, we have to go into litigation with companies that are not willing to make meaningful changes that will actually get to the root of problems in settlements. So we're forced to sue, and that is expensive and it is time consuming. So figuring out how to fix some of those asymmetries, as the chair said, would be very helpful.
Thank you so much. My time has expired, and now I call on the ranking member for 5 minutes of questions.
Thank you, Madam Chair. Appreciate it very much. During Joseph Simmons' confirmation hearing to be FTC chair, senators had the opportunity to ask him whether he would commit to running the FTC in a bipartisan manner. He, of course, agreed. Considering one of your colleagues is expected to be confirmed to another position, the FTC may soon be in a 2-2 split. And so it would be even more imperative that the FTC proceeds on a consensus bipartisan approach. Chair Khan, since the Senate did not have the opportunity to ask you, will you run the FTC? Again, will you commit to doing it in a bipartisan fashion where you will consult and coordinate with all commissioners and ensure they have the resources of the commission available to them on all pending business? Please answer yes or no.
Certainly, Congressman. I think this is a really fascinating moment for a new emerging bipartisan consensus, especially around some of the concerns relating to concentration of economic power in the digital markets, and I'm always keen to find areas of shared agreement with my colleagues.
Thank you. Our committee has worked extensively in a bipartisan manner to protect consumers from fraud and scams. Mr. Carter's Combating Pandemic Scams Act was enacted at the beginning of the year, thanks to all of our leadership here. Representative Blunt Rochester's Fraud and Scam Reduction Act, as well as Representative Kelly's Protecting Seniors from Emergency Scams Act, both cleared our chamber with bipartisan support this year. My bill, H.R. 2672, the FTC Reports Act, would require the FTC to report on fraud against our seniors. Commissioner Phillips, how important is the work the FTC staff does to protect Americans from scams?
Congressman, thank you for your question. The work we do to protect American consumers against frauds and scams is our bread and butter as an agency. There is no work that makes me feel better as a commissioner when we watch our ability to find bad guys who are taking money from American consumers, dipping into their life savings, and get that money back to them. So the work that you have done on the committee to provide funding and to provide tools for us to go after scam artists is critical, and I think that needs to continue at the agency.
Thank you. And Chair Khan, again, as you pursue other initiatives, will any staff and resources be shifted away from the fraud program, which is so essential in preventing bad actors from harming our constituents? That's the question, please.
Sorry, could you repeat the question? You're saying when should resources be shifted?
As you pursue other initiatives, will any staff and resources be shifted away from your fraud program, which is so essential in preventing bad actors from harming our constituents?
Well, of course, we're always limited by the appropriations bills when it comes to thinking through how we're delegating resources across the agency. In certain instances, I think there are exigent needs that can arise in certain aspects.
But you don't anticipate moving money from the fraud program, is that correct?
Not especially. I mean, I think overall we are trying to look through the prism of managerial efficiency and trying to understand how we can best use our resources, especially given some of the exigent circumstances, and so we'll be continuing to make those determinations.
I suggest that you not, because this is such a very important program. Commissioner Wilson, Can you elaborate on why the FTC Reports Act would also prove beneficial to increasing much-needed transparency and the flow of information within the Commission?
Thank you very much for the
you.
question, Ranking Member Bilirakis. As I explained in my opening remarks, there have been significant concerns regarding procedural irregularities and abnormalities in recent weeks. These are abnormalities that we did not experience under Republican Chair Joe Simons or under Democrat Acting Chair Rebecca Slaughter. We can agree to disagree. We can disagree without being disagreeable, but process matters. And so to the extent there are ongoing procedural irregularities at the Federal Trade Commission, I think that even more transparency will enable Congress to exercise its even more important oversight now regarding the actions of the agency.
Guess what? There's a vote. Another motion to adjourn. I don't know what to say. I know that Commissioner Slaughter has a hard stop, and I don't know about the rest of you. I think we need to vote and then come back as quickly as we can. If you're here, we'll appreciate it. This is very frustrating. Did you want to say something? Okay.
We're happy to stay. And
All right, we're going to go vote.
what does she ask?
Caster is the next question.
Okay, next for questions is Congresswoman Caster. You were recognized for 5-minute questions.
Well, thank you, Chair Schakowsky, for calling this hearing and for following through on working with me on a bill to give FTC APA rulemaking authority and first offense civil penalty authority in my 21st Century FTC Act. It's H.R. 4447. But before I ask a question on that bill, I'd like to first discuss a top priority for me, and that's children's online privacy. On July 9th, President Biden issued an executive order that directed the FTC to use its statutory rulemaking authority to address unfair data collection and surveillance practices that may damage competition, consumer autonomy, and consumer privacy. The FTC should follow through. They should follow through on President Biden's direction to use its powers to protect consumers' privacy, but while doing so, it should make protecting children's privacy a priority. And it's not just me that believes this should be a priority. I helped secure language in the Financial Services Appropriations Bill we're voting on this week that urges the FTC to prioritize investigations into potential violations of the COPPA rule, as well as requiring the FTC to submit a report on its enforcement of the COPPA rule. So, Chair Khan, will you commit to prioritizing enforcement of the COPPA rule and submitting this report in a timely fashion?
Thank you, Congresswoman. I think ensuring robust privacy protections for children in particular is paramount, and I certainly hope the agency will be able to commit its resources to focus on this important issue, especially during the pandemic when so many children have become even more reliant on ed tech services.
So can you give us an update on the status of the COPPA rule?
Of the COPPA rule?
Yes.
I understand a review has been initiated. I'm not precisely sure where we are exactly in that process. I know there have been concerns relating to whether any revision would be stronger than what we already have in place as opposed to weakening it. From my perspective, I think COPPA needs to be the floor, not the ceiling, and we need to question whether the type of notice and consent framework that informs some of the prior privacy rules are still adequate, especially when parents don't really have a choice as to whether their children are even using some of these technologies. But happy to follow up with your office on the specific where we are in the process.
Thank you very much. And Commissioner Chopra, you've been a leader here on when it comes to children's online privacy. What is your view for the agency going forward?
Yeah, it's very clear that many of these firms, whether it be TikTok or YouTube, are wanting the data of teenagers and children desperately so that they can monetize them and target them for the rest of their lives. I think the Commission learned a hard lesson in its YouTube settlement, which essentially allowed YouTube to pay a fine, but to keep the algorithms that were illegally enhanced by their spying on children, and essentially did nothing to fix the underlying business model that YouTube relies on to essentially target children. So we need to look, as Chair Khan said, at the underlying business model that is promoting so much of these privacy abuses. And I really agree with what you said. It has to be a priority. And we also need our state attorneys general joining with us to prosecute more of these cases.
And stay tuned. I think the Congress is poised to have more legislation to consider very soon. So switching to my 21st Century FTC Act, which gives the FTC APA rulemaking authority and first offense civil penalty authority, I'd like to ask two quick yes or no questions to each of you. One, should the FTC have more statutory authority to pursue civil penalties? Yes or no?
Yes, Congresswoman, I think it can help with deterrence significantly.
Yes.
And number two, should the FTC have a more streamlined and less cumbersome rulemaking process?
Yes.
Yes, that would be more equivalent to almost every other agency that polices against these abuses.
I think that's important for my colleagues to understand that the FTC is different. I'm going to ask one other follow-up question, Chair Khan. Who wouldn't want the FTC to have this kind of first offense civil penalty authority?
Frankly, it would be the lawbreakers who would not be disincentivized to not pursue these actions in the first place.
Do you agree, Commissioner Chopra?
Yeah, I think a big problem with the FTC as it currently is composed is that we cannot penalize some of this egregious conduct. We just hopefully can get money back, but there has to be a disincentive to do that misconduct in the first place.
Thank you very much. I've run out of time, so I yield back. Thank you.
I just want to remind members that there are other commissioners, I think, that are still on virtually with us, I hope. Now let me call on Representative Latta for his 5 minutes of questioning.
Well, thank you very much, Madam Chair, and thanks to the commissioners for being with us today. In recent weeks, the FTC has held 2 open meetings. While I'm glad to see that the FTC intends to increase transparency, the reality has fallen short. Any change in policy should not be rushed. It should be well communicated in advance to the public and ensure input is sought and considered ahead of any commission votes. Most importantly, having open, transparent meetings will allow the FTC to better serve the public interest. Similarly, in 2017, Chairman Pai increased the transparency of the FCC by publicly releasing documents weeks in advance of the open meetings, and Acting Chair Rosenworcel has continued this practice. Chairwoman Khan, will you agree to conduct future meetings and policy deliberation in a truly transparent manner?
Thanks for the question, Congressman. Let me just say up front, I'm so thrilled that we've been able to really start opening up our commission meetings. I think it can really help with democratizing the agency and enhancing public participation. And I'm so grateful both to the agency staff that have enabled us to do this in quick order and my fellow commissioners. Of course, we're still very early in the process, and so we're always thinking about ways that we can improve our processes going forward.
So, you will make sure that there are open processes and there's transparency.
Certainly,
I'm going to take that as a yes.
Certainly,
okay.
Yes.
Thank you.
Want to focus on clear notice for all market participants and the public.
Thank you. Commissioner Phillips, the FTC recently voted along party lines to rescind 2 policy statements that have been relied on under previous administrations of both parties. Were you consulted by the chair prior to the notice of the open meetings on this, or what could go into their place?
Thank you for the question, Congressman. I would say the level of consultation was as low as I've seen at the agency. And it's important to note that in terms of transparency, we didn't make transparent what our policies would be. I think Congressman Guthrie's act, putting out the policies 30 days in advance, giving the public a real opportunity for input is a very important thing that could, to follow on the words of the chair, really democratize the process. Let the public know what we're going to do. Allow for consultation with the public, allow for consultation within the commission. That's how you have a thoughtful process.
Thank you. Chairman Wilson, same question.
I completely agree with the comments of my colleague, Commissioner Phillips. And I would note that in terms of transparency and democratization, we actually, the Republicans on the commission, offered topping motions that would require the rescission of these important policy statements to be put out for notice and comment so that we could receive the input of all stakeholders before these important policy statements were rescinded. And in fact, the 3 Democrats voted against receiving input from the public on these important issues. Moreover, I would note that while it is wonderful to hear from the public in these new open commission meetings, we are hearing from them after votes are taken, and so they are not actually having an opportunity to weigh in on the proposals that we're considering.
Well, thank you. Madam Chair, I'd like to enter into the record the July 9 dissenting statement from Commissioners Phillips and Wilson regarding unfair methods of competition.
Without objection.
Thank you, Madam Chair. Commissioner Wilson, it goes without saying that our nation needs a privacy law. The longer Congress waits to enact bipartisan legislation, the more states decide to create their own laws. I'm concerned about this patchwork of state laws as it breeds confusion and leaves gaps in consumer protection. It's clear to me that we need a federal privacy standard to better protect consumers and streamline compliance. It's not realistic for small and mid-sized companies to follow 50 different privacy laws. It might also be unconstitutional. Would you expound on why it's important for Congress to create a national privacy standard?
Absolutely. I think this is an incredibly important issue and one that all of us at the Commission have spent a great deal of time talking about. And I know, in fact, this is an area of bipartisan consensus at the Commission. Commissioners Slaughter and Chopra and I have had extensive discussions about the need for federal privacy legislation. It's very difficult for businesses to understand the rules of the road, operating in 50 different jurisdictions with 50 different state laws, not to mention all of the international regimes. And with respect to citizens, privacy rights and transmission of data doesn't stop at state boundaries, let alone national boundaries. And so I would love to see the U.S. step up to the plate, take a seat at the table internationally by enacting federal privacy legislation that provides not just privacy for our consumers here at home, but also protection for important civil rights that are being eroded as we speak.
Well, thank you very much. And Madam Chair, my time's expired, and I yield back.
I now recognize the chairman of the full committee, Mr. Pallone.
Thank the chairwoman. I wanted to ask Chairwoman Khan about enforcement. Why is it so essential that Congress update the FTC's enforcement tools to maximize the Commission's limited resources?
Thank you, Chairman Pallone. The agency is severely under-resourced. We have less staff than we did back in 1980. Of course, the size of the economy has dramatically expanded since then, and we simply have not been able to keep pace. As I mentioned in my opening remarks, we are currently living through a huge wave of mergers and acquisitions, and I think there's a particular concern that unless we're able to closely scrutinize these deals, that our economy could end up becoming even more concentrated than it currently is and harming consumers, workers, honest businesses.
And then we've heard concerns from some on the other side of the aisle that providing the FTC with new authorities and tools such as civil penalty authority, APA rulemaking, might result in overreach that would put well-intended businesses at risk of unfair enforcement actions. But I wanted to give you a chance to respond to that concern. And in particular, do you believe that a more flexible and dynamic FTC actually benefits honest businesses, and how so?
Absolutely. There are ways in which rules can provide additional clarity for businesses. The Commission recently voted out Made in USA rules that would enable the FTC to penalize companies that are lying about their products being made in the USA. That's an example of a rule that's not imposing any new burdens, but is simply creating clarity and ensuring that the FTC can deter this type of conduct.
All right, thank you. And then let me ask Commissioner Slaughter. I think you said everybody's still here, right? Okay. Commissioner Slaughter, we've heard many times from the minority, I should say from the Republicans, that we need to move quickly to enact a federal consumer privacy standard with the FTC in charge of enforcement. But in my view, some of the bills that Republican members are proposing today would actually hinder the FTC's privacy enforcement. My two questions. Do you believe that any of the bills under consideration today, like the Time Act or the SURE Act, would hinder the Commission's efforts on privacy and data security? And if so, how? And then secondly, what changes to the FTC authority do you believe are critical to ensure consumer privacy is effectively protected, if you will?
Thank you, Mr. Chairman. I agree with the principle that we need to be on top of this important area of the economy, and I really appreciate this committee's attention to making sure we are adequately resourced in terms of both funding and authority to do that important work. I also share the view that some of the bills before consideration, while well-intentioned, before this committee for consideration, while well-intentioned, may have some problematic unintended consequences in terms of ensuring our enforcement can actually be effective. So, for example, I am concerned about limitations on the duration of our consent decrees. I think we need to make sure that we are tailoring case-specific resolutions that really ensure violations do not recur, and that we are doing that with the flexibility so that we can revisit those orders as circumstances require. I'm also concerned, for example, about the SURE Act that might embolden large companies engaged in data abuses to argue that any perceived injury from, for example, a free service cannot be unfair, or that it might encourage judges to take an overly narrow view of unfairness. Our enforcement burden to demonstrate unfairness is already extraordinarily high, and the cost to consumers and markets from that is felt every day. And then the last point I'll make is that I'm very sympathetic to the calls for transparency, for example, with reports, but I actually very much worry that any reporting requirement that isn't coupled with additional resourcing means that we are taking energy away from and staff attention away from protecting your constituents and putting it instead into paperwork. And so in terms of what tools we need, I absolutely agree with my colleagues that APA rulemaking authority would be helpful, civil penalty authority would be helpful, and I think fixing 13B would be very important, and adequately resourcing the agency to make sure that we can keep pace with the large companies across the table from us is critically important.
Thank you so much. I yield back, Madam Chair.
I now recognize the ranking member of the full committee, Ms. Rogers, for 5 minutes.
Thank you, Madam Chair. Recognize it's been a long day. Appreciate you all sticking with us and believe that this is a very important hearing today as we think through the FTC and the many issues before the FTC. Last month, we saw that the FTC went through some dramatic changes, including when it recently voted on a 3-2 party line vote for a structural change in its compulsory process. And this will provide de facto control by one person to issue subpoenas in competition cases without consultation with other FTC commissioners or bureaus. I don't believe that that's a new era to celebrate. These changes seem to be a clear attempt by the new chair and the Biden-Harris administration to consolidate power in order to pursue an agenda that will completely reshape our economy. I continue to hear that the FTC needs additional funding, staff, authorities. Some of the bills have been proposed today by the majority. But if decisions are being made behind the scenes unilaterally, it really makes it hard to justify such request. So I wanted to start with Commissioner Phillips. Should this compulsory process be at the discretion of one person? And can you briefly explain why it's important to have collaboration with experts and commissioners when issuing a subpoena under this authority?
Thank you, Congresswoman. So we do use single commissioner authorized compulsory process for a lot of the kind of bread and butter scams and frauds. But for the larger investigations, the antitrust investigations, all commissioners have until just weeks ago had the opportunity to look at what was going on, to ask staff questions, to try to make sure that the resources that we ask for from Congress are being used in a sound way.
Thank you.
These investigations are very costly.
Thank you, Commissioner. I'm trying to get through a lot here. Commissioner Wilson, would you briefly elaborate on it?
I completely agree with Commissioner Phillips. The issue here is that there is a consolidation of power that removes authority from the other commissioners to weigh in on important investigations, including the theories of harm being pursued and the scope of those investigations. At the same time, we have removed a lot of, we have lost a window into what staff is doing. And so because we are no longer getting compulsory process memos, we are unable to understand the theories of harm being pursued in investigations.
Great. Okay, thank you. So Chair Khan, I know you've expressed that the change of policy was to increase efficiency, but it seems communication and collaboration are lost in this efficiency, and the greatest effect is going to be the consolidation of power in your office. Can you commit to sharing all information related to the FTC compulsory process with your Republican commissioners?
Thank you for the question, Congresswoman. I should note that these types of omnibus resolutions have been routinely used on the consumer protection side for investigations into diet pills or massive privacy violations. And so we really were creating some symmetry between what's routinely done on the consumer protection side with the competition side.
What about,
I think this type of empowering staff can really make sure we're able to move forward on full gears and full speed.
What about communication with other commissioners?
Oh, absolutely, Congresswoman. Staff is always available to commissioners to provide analysis and assessment, and commissioners are routinely requesting that type of analysis and assessment from staff, and staff is providing it. So from that perspective, I think we're doing the best we can to make sure that information is available while dealing seriously with the severe resource limits we have.
You're the chair. You're the chair. You set the tone. And it appears that there is an effort to consolidate power and decision-making into your hands. That's not the way that it has worked in the past, and I don't believe that that's the way that's going to lead to the best outcomes. I do want to ask you on privacy, because I believe it is so important that we move forward on a national privacy standard. And we've seen how big tech can trample protections for all Americans. So to the chair, Chair Khan, would you be willing to support a privacy proposal from Congress that includes APA rulemaking authority, sufficient enforcement, continued coordination with state AGs, and additional staff and resources that is preemptive?
Congresswoman, certainly I think we need robust privacy protections, and I think direction from Congress on this front would be helpful. I think on the preemption question, there are always trade-offs depending on the specific context. I know in some cases we want to ensure that insofar as states are providing additional protections, we always want to be wary of the federal government stepping in and overriding states' efforts to protect their own constituencies. So I think we want to keep some of those considerations in mind as well.
I look forward to further conversations with you because I am concerned about rumors of the FTC acting outside of Congress and issuing a rule on privacy. And with that, I'll yield back.
Did you say she yielded back? Oh. Congresswoman Trahan, it's your 5 minutes.
Thank you, Madam Chair. And Chair Khan and fellow commissioners, thank you for your patience and for being here today to discuss how an essential agency can better protect our consumers. President Biden's most recent executive order promoting competition in the American economy encouraged the Commission to exercise the FTC's statutory rulemaking authority in regards to, and I quote, unfair data collection and surveillance practices that may damage competition, consumer autonomy, and consumer privacy. Now, in October 2020, Google Ads updated its policy to restrict the serving of high-fat sugar salt, food and or non-alcoholic beverages advertising for minors under 18 in the United Kingdom and in the European Union, but has refused to make similar changes here in the United States. A recent policy change by Facebook is a step in the right direction, but it's far from perfect when you consider that a May 2021 study by the Tech Transparency Project found that Facebook allows advertisers to target ads for electronic cigarettes, pill parties, and extreme weight loss products to children as young as 13 across the U.S. Plainly, Facebook and Google are using troves of personal data belonging to teens and adults to target harmful advertisements in ways that are not transparent to users. So, Chair Khan, would you consider these examples of the types of surveillance practices that may damage consumer autonomy and consumer privacy?
Absolutely, Congresswoman.
Thank you for that. And Commissioner Slaughter, if the Commission were to begin rulemaking today to protect consumers, including our children, from surveillance advertising, what would be the process under the Commission's existing MAG-MOS authority? And would the Commission face difficulties? If you could speak to that, it would be great.
Thank you, Congressman. It's a great question. And I want to start by responding to a suggestion from the ranking member of the committee that the Commission might act without Congress or outside of congressionally delegated authority. I want to be very clear. The Commission cannot, should not, and will not, with my support, act outside of congressionally delegated authority. But we absolutely should look at the authority Congress has delegated to us. And it has specifically delegated to us rulemaking authority under Section 18 of the FTC Act, which is referred to as MAG-MOS, to promulgate rules to address unfair and deceptive acts or practices that are prevalent in interstate commerce. And so data abuses could fall very much into that category. Rulemaking under Section 18, to answer your question briefly, looks like APA rulemaking, but with much, much more process. So we can't begin with a notice of proposed rulemaking. We have to begin with an advanced notice of proposed rulemaking that asks questions about the issues that we will consider. We have to notify Congress before we do that. We have to then, in a notice of proposed rulemaking, identify any issues of material fact that are disputed, and again, notify Congress. And if there are issues of material fact, the statute requires us to have an informal hearing to adjudicate them. So it is a very process-intensive statute that requires lots of and provides opportunity for lots of participation. It is absolutely burdensome to the Commission to do it. I think it's worth it for us to try, but we should make no mistake that it would not be a quick or fast effort.
I appreciate that. And it's, to note, it's unique to the FTC. If Congress were to provide the FTC with rulemaking authority under Administrative Procedure Act, how would that change the Commission's ability to protect consumers from harms associated with the surveillance advertising business model?
Well, what it would not change is it would not prevent participation in a rulemaking process. It would not allow the Commission to act outside the scope of the law as congressionally designated, any statute. So if it's just FTC Act law, then we'd still have to be looking at rules that target practices that are unfair or deceptive. We could not promulgate a rule that made illegal conduct that wasn't otherwise illegal, but we could do it with much more efficiency and fewer burdens so that we can really get to the material harms that are affecting people throughout our economy. You focused on children. That is an issue that's near and dear to my heart, but it's not with kids. It's competition, it's small businesses, it's civil rights issues, which Commissioner Wilson mentioned. So I think it's a really, really important area for attention.
Okay.
And the last point that I'll make is that rules also provide clarity to businesses about what is prohibited. That allows and facilitates compliance. It doesn't prohibit it.
Thank you for that. I yield back.
Mr. Guthrie, you are recognized for 5 minutes.
Thank you, Madam Chair, and I thank Ranking Member Bilirakis for holding this meeting, and thanks for the Chair and all the commissioners for being with us today. The Federal Trade Commission has a commitment to protect the American public from unfair and deceptive practices and unfair methods of competition. With that responsibility comes proper oversight, adequate transparency. However, recent activity by the FTC did not permit for adequate time for vetting and input from consumers. Before us today are two bills that I introduced, H.R. 4564 and the FTC Transparency Act and H.R. 2690, the CLEAR Act, both which would allow for more transparency and accountability at the FTC. Some of this was brought up by my colleague, Mr. Latta, and answered by Commissioner Phillips. But Commissioner Phillips, I want to talk specifically about my bill. My bill, the FTC Transparency Act, would require the FTC to publicly publish documents to be considered by the Commission on the federal agency's website at least 30 days before a vote. In your experience, Commissioner Phillips, how would a 30-day notice be helpful to your daily work and productivity amongst your colleagues at monthly commission meetings? And in your experience, how would a 30-day notice increase accountability and transparency at the FTC for American consumers?
Congressman, thank you for your question, and thank you for your leadership on this issue. A 30-day time period where the public could see what we are doing, and we could hear from the public, from the consumers that are affected by the harms, from the businesses that have to work under the potential regulation. We could hear about the impact of the policies, would inform what we are doing, and require us to take into account what we're hearing from the public, both the business community and consumers. That will create accountability. We're forced to listen to what people have to say and take into account what they say.
Thank
so
you.
I think that would be an essential reform.
Okay, thank you. And I would like to ask each, the chair and each commissioner, do you support the language, my language in the bill, to bring transparency to the FTC?
Congressman, certainly we want to be thinking through how we can increase transparency and public participation, and I'm so glad we've been able to do that. We are still early in our thinking of how to continue doing that, but always happy to take feedback and continue improving our processes.
So you like the bill, you're for the bill, or the language of the bill?
I'd want to make sure that it's not conflicting with other statutory obligations, for example, some of those outlined in the Sunshine Act, and happy to follow up with
but
you
don't have
on the details.
You don't have a philosophical issue with the 30-day requirement then?
I think with the general idea of providing notice, that's great, and we're happy to continue thinking about how to do that.
Thanks. So then I guess I got another question. I'll just,
sorry.
if the others would say, Commissioner, the other commissioners would just say their support, or?
Sure. I totally appreciate, the philosophical part of this, because the FTC for too long has been notoriously secretive. Most of what the commission does is it votes in secret by email, not even consulting anybody. That has been standard practice under Republicans and Democrats, and it has to stop. We need to actually be listening to people rather than just gathering in private and making secret decisions. I'm so glad we've moved to an open meeting concept. I think it's an important reform, and I think other reforms, too, to make us more transparent and accountable are worthwhile. I'm happy to look more at your bill and talk to you.
I'm going to have to move on, so I can get to the next one. Thank you for those comments. And then, Chair Khan, in light of the FTC's recent vote on the revised Section 18, which altered FTC's approach to prescribing new rules for unfair or deceptive business practices, how can you ensure that increasing efficiency by streamlining the rulemaking process will not result in a reduction of sharing information, transparency, oversight, and input from pertinent experts?
Congressman, the current procedures that govern those rules go, as Commissioner Slaughter mentioned, far above and beyond what's traditionally required under the Administrative Procedure Act. So even under the more streamlined procedures, there would be ample opportunity for notice and comment and for us to make sure we're really doing our homework before we issue any rules.
And Congressman, the proceedings are public.
So you think the increasing the efficiency is that you're looking for is going to ensure people have access to the information?
So the procedures that are currently in place continue to require extensive public input and including public proceedings.
Okay, thank you. And I'm running a low time, so I'll just leave it there. So, Chair Schakowsky, I would like to submit for the record Commissioner Phillips and Wilson's dissenting statement on the adoption of revised Section 18 rulemaking procedures.
Without objection. So ordered.
Thank you, and I yield back. Thank you.
I understand my colleague, Mr. Rush, is online, and you are now recognized for 5 minutes.
I want to thank you, Madam Chair, for convening this extraordinary hearing. You along.
Bobby, if you could speak up, that would be helpful.
You along with the ranking member, I want to thank you for convening this extraordinary hearing. Commissioner Chopra, as you know, earlier this year, the FTC, along with 38 states and the District of Columbia, shut down a massive fraudulent charity operation that built over $100 million from the American consumer. Under current law, the FTC must prove an organization is a fraudulent, nonviolent entity before being able to engage in enforcement actions. My bill, H.R. 3918, will make it easier for the FTC to go after these fake charities by finally giving you the authority over all 501c3 tax-exempt organizations. If my bill becomes law, how will this benefit consumers?
So, Congressman, there's no question that we have so many bad actors parading as nonprofits organized as 501c3s. They take in money, and the principals of these nonprofits siphon them away, but they can block FTC enforcement by saying that they're organized as a 501c3. For years and years, commissioners of both parties have supported a change to the FTC Act that would eliminate the nonprofit exemption so that we can go after this with more clarity and also address other anti-competitive practices by nonprofits.
Do you foresee any obstacles that may be a hindrance to those not-for-profits who don't have the sophistication and the finances to negotiate your oversight authorities and the FTC? And how would you How would you deal with that problem?
Well, I think where the issue is when the nonprofit is engaged in egregious fraud. It's pretty clear that they have engaged sometimes in even criminal activities. So, with respect to those fraudsters, I don't think many nonprofits are going to have a tough time complying with that, because most nonprofits are trying to do the right thing. So I'm happy to have further discussions on this, but I do believe that when we allow a nonprofit exemption, we create a loophole for bad actors to be able to figure out a way around law enforcement, and it is something that is just not good for an honest marketplace out there.
Yeah, I am particularly interested in whether or not this will have a chilling effect. I know it's needed. This is a necessary action. We need to give the FTC the power, but I'm also understand that in the real world that we live in, that this may have a chilling effect on faith-based not-for-profits and other not-for-profits. So I want to work with you to make sure that we send the right kind of signals that this is not going to be onerous to those not-for-profits who are doing good, honest, much-needed work to enhance the well-being of our citizens. Chair Khan, the FTC recently released a report and subsequent policy statements supporting legislation that would enable consumers to access data generated by their motor vehicles for repair and maintenance purposes. Restriction on this data access place a financial burden on too many hardworking Americans, and as the FTC report notes, this is particularly true for communities of color, such as in my district. I am drafting.
Congressman, we lost your audio.
We can't hear you now, right this second, Bobby.
All right. Can you hear me now?
Yes. I
am pleased to report that I am currently drafting legislation to address this very problem by requiring that vehicle owners have access to their repair and maintenance data, allowing them to choose how and where they want to repair their cars. Can you discuss why legislation like this is needed and what limitations does the FTC currently face under Section 5 authority under the FTC Act?
Thanks so much for the question, Congressman. Certainly, undue restrictions on repair have a very harmful effect on communities of color and marginalized communities in particular, and I think the type of legislation that you're talking about could go a long way in ensuring that manufacturers are not able to unduly control the data in ways that limit our ability to repair our own cars. And I'd be happy and eager to work with your office on thinking through what that type of legislation could look like.
The gentleman's time has expired, and now I call on Congresswoman Bouchon for his 5 minutes.
Thank you, Madam Chairwoman. Commissioners, thank you for taking the time to be here for the committee today. Commissioner Chopra, since you've been appointed as the head of the Consumer Financial Protection Bureau, or CFPB, Senator Toomey and the ranking member of the Senate Finance Committee has sent you a letter, which I don't think that you've answered to this point, asking for details on recent personnel changes at the organization. And so I'm going to take the opportunity to ask you some of those questions. And now that you're in front of the committee, would you want to have the opportunity to answer these? Maybe, are you aware of whether the CFPB has taken any steps between January 20th, 2021 and the present to push out, replace, or encourage any career CFPB employees to leave their positions?
Senator, Congressman, I have absolutely no involvement. I am not aware, did not direct, and have no participation with respect to activities related to the CFPB. I am currently an FTC commissioner with a busy docket. As I understand, the CFPB has replied to those letters to explain that I have not been involved. Those are decisions that involve human resources issues subject to very significant Privacy Act and other requirements. But I am currently full-time at the FTC until, if I'm so fortunate to be confirmed as director of the CFPB.
Fair enough. I won't ask you the remaining questions, then I'll just point out, I'll just say that there are reliable information. People have been offered substantial separation packages. People have been put under investigation to try to force them out. And also that people have been put on administrative leave if they're not in the correct political party. And, at federal agencies, these are people who are career people. All our federal agency people work very hard regardless of their political leanings. And I would hope that the things that Senator Toomey's concerned about are not true. So I'm going to ask you this then. While you're at the FTC, you've raised concerns about rebate walls and other conduct acting as barriers to effective competition, stunting the cost savings and innovation expected in an unconstrained marketplace. In a statement, you warned that rebate bundling is undoubtedly a fixture of the competitive environment in immunology, that such practices are suspicious and might act as a barrier to entry and expansion for drug makers with less bargaining leverage. Could you comment on that?
Yes, I am very concerned that drug makers often engage in complex rebating strategies in ways that prevent new drug makers from entering and challenging their dominance. The net effect of this is that we could have less innovation and less competition for life-saving drugs. I'm worried that these rebate walls may also constitute violations of the law in certain circumstances, and I think it's important not just for the FTC, but also state attorneys general and others to really look at this. The Trump administration also sought certain policies to crack down on this, and it's one we have to really take seriously if we want there to be affordable drugs.
Sure. Again, sorry to focus just on you, but as the FTC continues to monitor for anti-competitive practices that make life-saving biosimilars more expensive for people from Indiana, Hoosiers, it would make sense to perform cost-benefit analysis on FTC recommendations to project impacts on markets. Would you support performing a cost-benefit analysis of measures to address this important issue to ensure that policy changes will accomplish what they're designed to do?
So during the past 3 years at the FTC, I've been a strong advocate for more analytical rigor. I am very concerned that the quality of rigor that is used to make decisions across the government is far too low. We should be incorporating information from the life sciences industry, quantitative information, and qualitative information from our pharmacists and others in the medical supply chain. So having that full range of evidence and being rigorous. Of course, economics is one part of that, but we need a full range of data and evidence to make sure that anything we do actually benefits competition and doesn't make things worse off for patients.
Fair enough, thank you. So I have introduced H.R. 2676, which would require FTC's Bureau of Economics to conduct a cost-benefit analysis for any legislative, regulatory, enforcement recommendations, including a rationale for the FTC's determination that private markets or public institutions could not adequately address the issue that is subject of the recommendation. So my feeling is if we let the market work, most of the time it does, but occasionally we do need the federal government like the FTC to make sure that that's happening. So thank you for your answers, and I yield back.
Mr. McNerney.
Madam Chairwoman, I forgot to, can I ask unanimous consent to introduce Senator Toomey's letter into the record?
Without objection.
Sorry about that. Thank you very much.
Mr. McNerney, you are recognized for 5 minutes.
Well, I thank the chair for recognizing me, and I thank the commission for testifying today. And congratulations, Chair Khan. One of the bills.
If I could just interrupt for a second, I just wanted to inform everyone that Commissioner Slaughter did have to leave. The others are here. Thank you.
I was just going to say, I really am so sorry, and I thank you for your time, and happy to answer any questions the committee has promptly in writing. So I appreciate your indulgence.
Thank you. Excuse me, Mr. McNerney. Go ahead.
Thank you. One of the bills we're considering today is H.R. 4530, legislation that I authored, which would establish an Office of Technologists at the FTC. As an engineer, I think it's critically important that the agency has that sort of expertise. Chair Khan, can you discuss the importance of having technologists at the agency and how having more technology on staff can help you carry out your mission? I know you're going to follow up on what Commissioner Chopra just said. Thank you.
Thanks so much for raising this, Congressman. It is imperative that the agency be fully equipped with a whole range of skill sets. I think ensuring that we have technologists on board is paramount, especially as we confront all types of new business practices in digital markets. I'm so thrilled that I was recently able to announce a chief technologist at the agency, and she's helping oversee our expansion on this front. So definitely plan to bring on more technologists.
Very good. Commissioner Chopra, following up on that question, how would this legislation be helpful for the agency in carrying out its work as it relates to artificial intelligence and how that's impacting consumers?
Yeah, so artificial intelligence is really changing the way so many different types of businesses operate in terms of making decisions when it comes to offering products or services. And one of the things we have to worry about is who's accountable when those AI machines break the law. How do we audit them? How do we know what's actually behind that? And without technologists and people with real skills related to data, data aggregation and analysis, we won't be able to do it. And I think this is critical that we muscle up when it comes to tech talent.
Very good. What about privacy and data security?
Yeah, I mean, the recent breaches that we've been seeing, as well as ransomware attacks, are really a reminder that the FTC is behind the 8 ball when it comes to catching up and making sure that we're securing the infrastructure of our country. This is not just about protecting consumers, it's about protecting our national security as well. And we need engineers and experts who can help us inform the right types of interventions and policies.
Thank you. And lastly, what about protecting consumers against the new kinds of scams that are happening online?
Yeah, you know, Chair Khan mentioned that a lot of the scams and frauds are being amplified by big tech platforms, algorithmically targeting individuals who are likely to be susceptible. If we are not able to dig in and understand how that targeting works, how those algorithms work, we will not be able to hold them accountable when they are amplifying fraud. We can't just go after fraudsters one by one. We need to look at the gatekeepers and those who profit from amplifying them as well.
Thank you. I also authored H.R. 4475, the Protecting Consumers in Commerce Act. This bill would give the FTC authority over certain common carriers. Commissioner Chopra, if enacted with this legislation, what would this mean for consumers, especially in a district like mine, which is economically a hard-hit district?
Yeah, you know, when it comes to telecommunications common carriers, they're completely exempt in many ways from the FTC's jurisdiction. That makes it harder to go after robocallers. That makes it harder to go after some of the ways in which companies target the elderly. We've tried to do our best when it comes to going after voice over IP providers and others, but the big carriers have a big role in all of these issues, and there's an uneven playing field when they're completely exempt.
Thank you. Chair Khan, do you have anything to add to that?
I would echo that and note that I think that type of exemption would really ensure that we can robustly enforce in a more symmetrical way across industries.
Thank you. Chairman Khan, I also co-chair the House Artificial Intelligence Caucus, and a key priority for me is to develop policies that help promote opportunities in artificial intelligence while tamping down whatever problems might arise as a result of artificial intelligence. What potential risks are you concerned about with respect to artificial intelligence, and what steps do you think the FTC should be taking?
Well, I think there are a whole range of opportunities, but also potential risks as this technology becomes more widely adopted. I know there have been a whole set of civil rights groups that have raised concerns about how this technology could exacerbate discrimination. For the FTC, I think foremost, the FTC needs to be making sure that we're fully understanding this technology. Congress really designed the agency to be a watchdog across the economy and closely study new business practices, new technologies to make sure we can keep pace, and I very much hope that we'll be doing that in this area.
Okay, and that goes back to my HR 4530 to create an Office of Technologists. Thank you. I yield back.
Now I'm happy to call on and recognize the always here Congresswoman Lesko.
Thank you, Madam Chairman, and thank you to all of the witnesses, whether here in person or virtually. I'm going to read a couple statements from the dissenting statement of Commissioner Christine Wilson on the Open Commission meeting on July 1st, and then just ask a couple questions related to it. So it's just excerpts from that. She said, I only learned last Thursday of the chair's intention to hold this meeting. At the same time, I was informed of her intention to hold votes to rescind the Section 5 policy statement and to pass several omnibus resolutions that would remove from Commission oversight large swaths of Commission business. Chairman Khan, the decision to hold open meetings can only be applauded if people know about it in advance, so it gives them enough time to prepare and actually show up to the meetings. So it was concerning to me that it seemed like there was not a lot of advance notice on the July 1st meeting, and that people couldn't prepare that. Why did you do that, and what do you plan on doing in the future so that the public has sufficient time to prepare for the FTC open meetings and can have public input? Because don't we want public input?
Absolutely, Congresswoman, and I'm so thrilled that we've been able to switch to this open commission format to provide more accountability and insight into the commission's work. This is new for the agency. As my colleague mentioned, we have a history of doing all of this behind closed doors, and so as we adapt to this new format, we'll be thinking through how we can continuously improve our processes and always appreciate feedback on that front as well.
Well, thank you for that answer, although it seems in contrast to what one of your other commissioners is saying. Again, I'm going to read excerpts from Commissioner Wilson, and then if I have time, give her opportunity to speak. It says, unfortunately, the format the chair has chosen for this meeting omits our knowledgeable staff and precludes a dialogue among the commissioners. And then in another portion, in another page, it says, following our rulemaking spree in the 1970s, the FTC was stripped of funding, stripped of legal authorities, and required to institute new and substantial rulemaking steps to foster public trust on our trade rules. Recognizing that this agency was on the brink of being shuttered, our rules of practice adopted a number of rulemaking procedures that provided for additional public comment periods, publication of a staff report, and multiple opportunities for the public to weigh in on disputed issues of material fact. And she goes on to say that the FTC has built transparency into our rules of practice by requiring that rulemaking staff publish a staff report containing that their analysis of the rulemaking record and recommendations as to the form of the final rule, but the new rules eliminate the staff report requirement. So my second question to you, Chairwoman Khan, is actually a question she put in here. And it says, in what ways will the public's understanding of any final rule suffer because the Commission will no longer publish a report from an expert FTC staff highlighting key issues and formulating recommendations based on the record? Why would you change this longstanding staff being able to do this staff report?
Well, Congresswoman, staff analyses and input is embedded throughout our various processes. There have been instances, frankly, when the Commission has handicapped itself by imposing on itself procedures and processes that Congress did not require. And so, frankly, some of our initial efforts have been to ensure that the FTC is abiding by instructions received from Congress and make sure we're in close alignment with the instructions that we're receiving from
And
lawmakers.
with the last 31 seconds left, Commissioner Wilson, would you like to respond?
Thank you very much, Congresswoman. Yes, I think it is important to recognize that the FTC is set apart from other federal agencies with respect to the Magnuson-Moss Act and these special rulemaking requirements, but it is set apart precisely because of the breadth of our jurisdiction and the discretion that we have. We have authority to regulate across the entire economy. We are a generalist agency. We are not like the EPA or the Department of Transportation that has relatively narrow authority for a single sector. And with that broad power and that broad discretion, we need to have sufficient guardrails to ensure that we are receiving input, that we understand what the evidence is with respect to impacts and possible unintended consequences of our actions. And so the safeguards in rulemaking that were abolished by the majority at the Commission, unfortunately, are going to diminish the quality of that decision making and, I'm afraid, stifle innovation, harm competition, and hurt consumers.
Thank you, and I yield back.
I recognize now Congresswoman Dingle for 5 minutes.
Thank you, Madam Chair, for holding this hearing, and to all of you who are testifying today. And I'm sorry you're all still having to be here in the craziness of our day on Capitol Hill. First off, there's been some discussion regarding process concerns at the FTC. Commissioner Chopra, when Democrats were in the minority, did you have access to all the information you wanted access to?
No, I was routinely denied the ability to participate in major decisions around second requests on mergers, the scope of subpoenas for major privacy investigations. These functions were routinely denied to me.
Thank you. Chairwoman Khan, in my view, a number of bills we're discussing today could have detrimental effects on the FTC's ability to carry out its essential consumer protection mission, which is what the job of the FTC is supposed to be, protect consumers. H.R. 2702, the SURE Act, codifies select portions of the FTC's statement on unfairness. The bill focuses on portions of the statement that discuss substantial injury, but ignores other portions of the statement, including a discussion of circumstances in which public policy concerns will independently support action by the FTC. Chairman Khan, can you tell us about some cases in which the Commission relied on the public policy standard?
Congresswoman, thanks for the question. I think as a general matter, ensuring that we're able to take into account some of those public policy considerations is always important, especially when we're encountering new contexts and new fact patterns. I think with that bill in particular, there is some concern that importing that substantial harm standard could make it more difficult for us to go after companies that are enabling data breaches, that are engaging in privacy violations. In those types of cases, it can be many years sometimes before which that harm is concretized. And so I think we want to be mindful about some of those potential trade-offs as well.
So I'm going to ask you for a short answer because I want to get to another bill. But if this bill becomes law, could the Commission be able to bring those types of cases in the future?
I think it would make it significantly more difficult.
Thank you. Another bill I want to address is H.R. 2677, the Time Act, which would limit consent orders to 8 years and require review and termination of consent decrees after 5 years in some circumstances. Instead of the company proving that a consent decree is no longer necessary, the burden would be on the FTC to prove that it's still necessary. Chairman Khan, how long are consent orders usually in place for, and why is that the case?
There's a range depending on the consent decree. In some cases, it has been, somewhere between a decade to 2 decades. I will say overall, there have been cases where firms have violated consent decrees well over a decade after we entered into them. And so I think from that perspective, there would be serious concerns about reducing the default length of some of these decrees.
I've heard concerns that the 5-year requirement in this bill would effectively limit consent decrees to 5 years. Is it possible that this bill would force inappropriately short consent orders?
I think that's certainly a significant concern.
In most cases, the FTC can only collect civil penalties on entities that are under order. Can you talk about how this bill could insulate repeat offenders from having to pay fines for wrongdoing?
Certainly, the agency has, in several cases, encountered recidivism and has had a difficult time ensuring that actors that are violating the law are deterred from doing so again. And so I think with any type of reform, we want to be mindful about that dynamic.
Okay, I'm going to go to another bill. H.R. 261, the SHIELD Act, prohibits the FTC from taking enforcement action based on noncompliance with agency-issued guidance. Chairwoman Khan, does the FTC do that now? Are enforcement actions brought based on a company's failure to follow guidance?
No, Congresswoman, guidance does not carry the force of law, and so we're not permitted to do that.
In contrast, under the SHIELD Act, companies can use adherence to agency guidance to prove that they did not commit an unfair or deceptive act or practice. Chairman Khan, what if the guidance was outdated? How could this bill make it harder for the Commission to bring cases against bad actors? And would this add another burden on the FTC by requiring it to prove why the guidance isn't relevant?
Certainly, I think there would be some concerns around that, especially if we're in a world where guidance cannot be used as a basis for finding legal violations. But then if it is instead being used as a way to shield companies from legal violations, I do think that there would be an asymmetry there that would be a little bit difficult to make sense of. So I think we'd want to be consistent across the board there.
Thank you, Chairman Khan. I'm out of time, so I yield back.
Well, thank you, Chairman Chakowski and Ranking Member Bilirakis, for holding this hearing. Thank you to the commissioners for being here today. My question is going to focus on the ownership of telematic or equipment-produced information. That's my word, not a technical word. I will use one example to define my concern. While this is a specific example, I believe that it represents an enormous and growing IP ownership issue. And let me begin. As the crossroads of America, Indiana plays an important role in the transportation industry. Our interstate highways connect regional hubs that are critical to the delivery of goods across the Midwest and the rest of the country. Leading the transportation companies, such as Honda, Toyota, and Cummins Engine Company, have footprints in my district to take advantage of local manufacturing expertise. Considering the presence of the auto industry, I have a particular interest in the Commission's recent actions on the alleged repair restrictions, and I say alleged, that may be imposed by original equipment manufacturers or OEMs. I've heard from several Hoosiers, both repair shops and OEMs, regarding access to repairs for telematic data and software on next-generation vehicles, and I think this may apply to any type of relationship between the owner of a piece of equipment and the manufacturer. I understand the concerns of manufacturers that need to protect the privacy of drivers and mitigate cybersecurity vulnerabilities of the vehicle. I also understand the concerns of auto repair shops that provide a valuable service to an industry out in the local economy. The auto repair industry itself supports over 17 jobs in my district and $7.5 billion in economic activity every year. Our rural Hoosiers that live prohibitively far from dealerships have to use third-party repair shops that may be their only option, especially if the vehicle breaks down and they can't get to, say, the dealership, if you will. Chairman Khan, I understand that your commission recently issued a policy statement that seeks to address potential concerns with limiting or restricting third-party access to telematic information. Can you walk us through the process that you use, that the Commission uses to determine that this policy statement was necessary, and where are you really kind of going with this as it would apply to much more than dealerships and auto repair shops?
Certainly, Congressman. So this policy statement followed a whole range of work that the Commission had been pursuing in this area. The Commission held a workshop on some of these repair restrictions, and under my predecessor, Acting Chairwoman Slaughter, issued a report identifying its findings and, as a general matter, noting that in many cases, some of these repair restrictions are overbroad and are being used in ways that harm individuals who are owning products, harming independent businesses that might otherwise have opportunity in these repair markets, and that the FTC really needs to scrutinize some of these practices more closely. I was pleased that we were able to adopt a policy statement unanimously at our last open commission meeting with an eye to addressing some of these restrictions using a whole range of tools, including our MAGMOS authority, looking at them under the unfair and deceptive acts or practices provision, as well as scrutinizing these for potential antitrust violations. So that's the path forward that we've laid out, with a commitment to really devoting more enforcement in this area.
If I can just add, Congressman,
Sure.
the existing law that's been on the books for about 40 years restricts the ability for manufacturers and sellers to condition a warranty based on using certain types of repair services, or there's an anti-tying provision.
Right.
So I think there's a perception that maybe we've not allocated enough enforcement resources to address those. It's becoming very difficult for many people to repair phones, tractors, so many other things which may be covered by that warranty. That's existing law that Congress passed. It's one of many laws that the FTC just hasn't really enforced, that Congress has told us to. And I think it's appropriate that if Congress has told us to enforce a law, that we do it.
So, and I'll kind of get a lot more into this as time goes by. But you know, let's say when I buy a car and my time's running short, I sign away that information back to the manufacturer. And there's many things that we click on, and we give somebody else our information. And then when we need it to repair or whatever, we don't have that information. So if you would kind of keep looking at that and find an equitable way to protect the customer in that area. Thank you, Madam Chair. I yield back.
Congresswoman Kelly, you are recognized for 5 minutes.
Thank you to Chair Khan and all of the commissioners for testifying today before the committee. I know that this past year has been particularly trying for the Federal Trade Commission. I also want to thank Chair Schakowsky and Ranking Member Bilirakis for holding this legislative hearing and for including my bill, H.R. 4460, the Consumer Equity Protection Act. This bill would establish a task force within the Federal Trade Commission to advise on equity issues in the protection of consumers and to prevent unfair and deceptive practices targeting consumers on the basis of race, color, religion, and other protected characteristics. This legislation is urgently needed since minority communities are disproportionately found to be victims of fraud. For example, African Americans are 3 times more likely to experience debt-related fraud than non-Hispanic whites. Often, this is a result of information not reaching vulnerable communities or victims not knowing how to report being victims of fraud or abuse. Chair Khan, how would forming a task force within the FTC assist you with protecting minorities in America from fraud and abuse?
Congresswoman, let me say up front, I'm just so glad and grateful to you for drawing attention to this issue. The FTC has confronted numerous instances in which companies have been violating civil rights protections like ECOA, and I worry that the methods of discrimination are becoming even more sophisticated and subtle as some of these technological tools are enabling discrimination and targeting. So I think this type of focus and bringing this lens to our work is going to be imperative.
Thank you. Commissioner Chopra, do you have anything else to add?
No, I just add, Congresswoman Kelly, that, you know, we had a previous question from Mr. McNerney about artificial intelligence and algorithms. You know, the more and more that large firms, especially the tech platforms, can systematically engage in, you know, essentially biased practices. Secretary Carson, when he was HUD Secretary, issued a complaint against Facebook regarding its practices on discriminating in housing. And I think we have to really wake up to the fact that a lot of these subtle forms of discrimination are done algorithmically, and they must be held accountable, particularly when it comes to the largest and most powerful tech firms.
Yes, my former colleague, Will Hurd, and I did a year study on artificial intelligence, and that was one of the things that we looked at. In 2016, the FTC released the Combating Fraud in African American and Latino Communities, the FTC's comprehensive strategic plan. In the report, it highlighted that the FTC would work to build networks with community organizations and visit areas with low rates of consumer fraud reporting. Chair Khan, how do you plan to improve communicating consumer protection issues to hard-to-reach communities?
Congresswoman, this is such an essential issue, and I think we need to think hard about how we can improve on this front. One priority for me is really focusing on building out our regional presence. We already have a whole set of regional offices, and I think they can provide a really great way to directly connect with communities that might otherwise not be directly hearing the work and listening to the work that we're doing. And so I think it's incumbent on us to make sure we're directly reaching out to those communities and making sure that we're helping all Americans.
Thank you. I think that all of us here would agree that the FTC is under-resourced and the role of the FTC is only likely to increase in coming years. So Chair Khan, do you think more resources are needed for the Technology Enforcement Division, given the public's attention on big tech and competition generally? And how would you utilize additional resources for addressing privacy and data security?
Certainly, I think more resources would be important for our ability to be able to do this work in a more comprehensive and effective way. In terms of where the specific needs are, I think hiring more technologists, hiring more data analysts, hiring more financial analysts, really making sure that we're equipped with the skill sets and tools that are allowing us to, at the very least, understand these business practices is going to be imperative. And so I think that will be an important step forward as we figure out how we can make our enforcement in these markets more effective.
Thank you much. And Madam Chair, I will yield back 10 seconds.
Thank you, Madam Chair. Commissioner Phillips, you and I have previously discussed your hesitation in using data privacy indicators during an antitrust analysis. Yet, as we know, the consumer welfare standard, and that might be a little up in the air right now, which if I get time at the end, I'd like to ask a question, is not solely about price. In fact, oftentimes when you see some of the large tech companies' attorneys testify, they dance around this question pretty well. We were lucky enough to have the CEOs in this committee testifying, and they were a little more brutally honest, which I appreciated. But it's not solely about price. It can be applied to non-price determinants like quality, variety, and innovation, although it is more difficult to assign any kind of quantitative value to those indicators. That's a challenging aspect of the current antitrust scrutiny on large technology firms, many of which provide services free to their users. And this is assuming we apply the consumer welfare standard to the user of the tech service. It is even more complex when we understand that the user is almost always not the customer. The user is the product, or alternatively, their data is the product. So ultimately, Mr. Phillips, who is the consumer in this analysis? Is it both, and you have price and non-price competition coexist? Did we lose him?
Noah, are you on mute?
Forgive me, Congressman. Sorry about that.
No problem.
I was saying...
I'm sure it was really smart.
I don't know about that. I think you hit on two really important areas of complexity. So one area has to do with what consumer we're looking out for. And where you have two-sided markets, let's say I provide you a free online product and I make my money on the other side selling ads to companies that want to sell ads. We, under certain circumstances, are compelled to take into account both just in the initial part of the case, that's under prevailing law today. But at the end of the day, we absolutely do need to think about the costs and the benefits of the conduct in question. With respect to privacy and consumer welfare, privacy can be an aspect of competition, and the consumer welfare standard absolutely can reach it. But privacy is a little more complicated. for two reasons in particular. The first is that people have different tastes for privacy. If you walk by a Starbucks and get an ad because you're physically close to Starbucks for a latte, you might respond and say, wow, that's creepy. They knew I was here. Or you might say, hey, great, I got this ad. And because different people assimilate that experience differently, we have to look with more of a fine-tooth comb and really understand how the consumer is being affected. The second thing has to do with the fact that there are things that consumers absolutely do prefer. They do prefer lower price, for example. They do prefer more choice. I just think we have to look with a great deal of care.
I think there's a couple other issues with privacy, maybe a little more fundamental, which in my experience is every time one of these companies increases your privacy, which I think we all appreciate, it often has the benefit of increasing their market share as well. And listen, we've had these conversations a lot. That's the difference between energy and commerce sometimes and antitrust. Sometimes what we're trying to do in one level is not always going to be consistent with the other level. And I think that's particularly true with the consumer welfare standard. I have concerns about the 2015 removal policy statement that articulated antitrust principles that guided the Commission's authority, which included the 2015, which included the consumer welfare standard, which has been established as jurisprudence for decades, and the rule of reason, which has been established for over a century. And I will admit, and I think, I'm guessing you'll all agree with me, that some of the tech platform issues that we face in these areas are very, very unique. And part of the reason is who is the consumer, who is the customer. But I'm concerned by the fact that the Commission did not replace the 2015 statement with a new policy that would at least provide notice on the Commission's planned antitrust enforcement action. And without such a replacement policy, what restrictions, if any, are placed on the consumer's antitrust enforcement practice right now? But my question for Mr. Phillips, and then if we have time, one more, and this will probably be my last one because I'm rambling. Do we have concerns about antitrust legislation that looks different for certain economic sectors? Do you think there's challenges to platforms that are different than other areas of antitrust?
There sometimes are. Some of the platforms have network effects that are a kind of efficiency, if you will, but basically the more people use it, the more popular it is for the users. And they can have indirect network effects. The more popular it is for me as the user, the better it is for you as an advertiser. And there are some aspects of these markets that are a little bit different. On the other hand, they're hardly the first markets like these. So telephone networks, railroads, these are just a couple of examples in American history where we've seen these effects. But I think your point that sometimes when people do things in the name of privacy, it can hurt competition, underscores the point that it is not as simple as saying this conduct increases privacy, ergo it's good. When we're doing competition law, what we need to look at is what is the effect on competition.
Congressman, could I just add, I think you raised concerns. Yes, the Commission did rescind the Obama FTC's policy. The Obama FTC policy statement was unmoored from what Congress specified in the law and has essentially rendered it dead letter. I think the Obama FTC policy statement has undermined our ability to scrutinize some of these tech platform issues, and you are right. We need to be able to communicate how that will be applied, and I know as the chair has said in the past, we will be doing so in the future, but we cannot just relegate that policy statement to essentially veto the law. It is not the Federal Trade Commission's ability. We are not supposed to veto or repeal laws. That's what you guys do.
The order in which you communicate and regulate gets important. Thank you both. I'm sorry for going over.
Thank you. Congresswoman Rice, I am recognizing you for 5 minutes.
Thank you, Madam Chair. The FTC has a long history of protecting our military veterans and service members from fraud. That is partly because protecting vulnerable consumers is the FTC's main mission, but also because military veterans and service members, despite making the biggest sacrifice for our country, also have a long history of being targets of fraud and scams. To assist the FTC with its mission and to protect our military veterans and service members, I introduced the Veterans and Service Member Consumer Protection Act of 2021 with my friend, Congressman Fred Upton. The bill would establish a coordinator within the FTC to educate military veterans and service members on schemes particularly targeted at them and teach them how to react to and report these schemes to the FTC. It would also require the coordinator to maintain a public-facing website with resources for military veterans and service members and establish a procedure for receiving complaints made by military veterans and service members at the FTC. So I would ask all three of the witnesses who are left if you could talk about the importance of having a coordinator for military veterans and service members, and why would centralizing this position be helpful?
So Congresswoman, you're totally right. Service members and veterans actually report, for example, identity theft at a much higher rate than the general public. There's a whole host of schemes that target the military community. You know, I've been disappointed. I think the Congress gave us jurisdiction to enforce the Military Lending Act 2013. We've not brought a single action. I think that needs to change, and we need to sharpen our focus on how we work with, for example, the Undersecretary for Personnel and Readiness at the Pentagon, who helps, broadcast where people should be on alert. So just as we have an elder justice coordinator, I think you're right that we need to really make sure we're focusing and centralizing some of our work when it comes to policing against abuses targeting service members and veterans.
Chair Khan.
I would echo that and note that, as you stated up front, we have seen in our work that military members and service members are particularly targeted, including by for-profit schools and payday lenders, and so making sure that we're squarely focused on these harms to some of the most vulnerable members in society is imperative.
And is it Mr. Phillips who's online?
Congresswoman, yes, it is. And thank you for your leadership on this issue. I think it's really important. I think having a coordinator not only helps to focus us, but it puts a lot of emphasis on something that you mentioned, and that is the consumer education that we do, teaching service members and their families how to deal with some of the scams that they see. There's a lot of important work that we do enforcing the law and in penalizing those who violate it, but teaching people how to fend for themselves is a very important complement to that. So I really appreciate your leadership on this and your focus on that critical area.
Great. I was glad to see that President Biden's recent executive order on economic competition urged the FTC to ban or limit non-compete agreements. This action will go a long way to help workers. Today, it is estimated that 1 in 5 workers without a college degree are subject to non-compete agreements, and 30 to 40% are not asked to sign these agreements until after they have accepted the position. But we have seen that competition in labor markets actually empowers workers to demand higher wages and can increase innovation as well. So I'm very supportive of my colleague from San Diego and a member of this committee, Congressman Scott Peters' bill, the Workforce Mobility Act, which would place strong limits on non-compete agreements. So I would put this to Chair Khan. To what extent would a clear expression of congressional intent, such as the passage of the Workforce Mobility Act, help to shape the FTC's policy and enforcement agenda with regard to non-compete reform?
Congresswoman, I think clarifications from Congress are always helpful, especially in cases where we'd be using, say, certain types of rulemaking authorities that the agency has neglected over recent decades. And so those types of express authority are always a helpful way to boost our work.
Would you agree, Mr. Chopra?
Yes, I think these non-compete agreements, it's not just low-wage workers, it's even doctors and medical providers who are trapped and are being essentially forced to move to an entirely different metropolitan area to continue their profession. This is bad for economic growth. It is bad for our society, and we need to take a close look, and I'm glad Congress is looking to.
Thank you. And I'm out of time, so I don't think I'm going to get to Mr. Phillips unless the chair let him respond. So, thank you.
May I thank you, Congresswoman. 2 points. The first is I do think when it comes to rulemaking, it's very important that we have a congressional directive. I think that the focus on labor mobility in the EO, the executive order from the president, on non-competes, on occupational licensing is a great focus. Allowing people to move around gives them bargaining leverage in their job and helps allocate labor resources in a way that also helps businesses.
And this is Commissioner Wilson. I am still on as well. And for the sake of time, I will just echo the remarks that Commissioner Phillips made.
Now I recognize Congressman Soto for 5 minutes.
Thank you so much, Madam Chair, and to our FTC commissioners, thank you for your patience. We've been through a bunch of unnecessary motions to adjourn today, and we respect your time. So I wish things were a little smoother. Thank you for sticking with us. We know we just passed a key bill to help out with restoring your restitution authority, the Consumer Protection and Recovery Act, and allowing the FTC to get fraud victims back, allowing you to get ill-gotten gains from con artists and criminals, even though a recent Supreme Court case sadly took it away. We know COVID's only increased the scams throughout this pandemic, being everything from stimulus check scams to paycheck protection loan scams to vaccine scams. In Florida, we even had a miracle mineral solution scam to sell a solution primarily made up of bleach out of Miami, Florida. They sold tens of thousands of bottles and made over $1 million. It's critical that we give you all the tools you can use to handle this. And the 10-year statute of limitations is an important clarification. It's a compromise. And we applaud you on some major victories, including the Volkswagen and DeVry cases that would have exceeded the 5-year statute of limitations if that was what we ended up getting. So to our commissioners, and it'd be great to hear from each of you, does the current budget give you enough resources to be able to enforce the Consumer Protection Recovery Act when it becomes law? We'll start with, yeah, please continue.
Thanks, Congressman. As a general matter, the agency is significantly under-resourced, and additional resources to be able to boost our enforcement across these areas is essential. I think there are questions about how we can be more effective in our enforcement, especially when it comes to the types of frauds and scams that you mentioned. So this is certainly something that we'll be thinking about.
And Commissioner Phillips.
Thank you, Congressman. I just start with the fact that when I began, our budget was about $309 million, I think something like that, and the latest congressional budget justification has us at $389. So there's been a substantial increase in the ask, including some funding from Congress. So I think it's important to track how those resources are used, but I do think we can do more with more. That's certainly a true thing, but I think it's important to take care in how we spend what we have.
Thank you. FTC Commissioner Chopra.
Sir, I know every agency says that they need more resources, but just looking at the data, we are stretched completely to capacity and the rubber band is snapping. And if we need to effectively enforce the law, we need the resources. There are so many laws that Congress has recently passed, whether it relates to opioids or so many other topics that the FTC has not brought a single law enforcement action on. That's not just resources, that's also commissioner accountability, but resources will certainly help.
Commissioner Slaughter.
So Commissioner Slaughter had to leave, but okay. Commissioner Wilson is here, and I would say that our hardworking staff have been even harder working during the last 18 months. They are teleworking, but they are working incredibly hard to stay on top of the increase in mergers as well as the increase in COVID scams. And I agree with Commissioner Phillips. It's important to understand how we are spending additional appropriations, but I also know that there are many different areas of the economy where Congress has expressed interest in our being very active and aggressive, and it is difficult to do that unless we have the appropriate resources to do that.
Thank you, Commissioner. And as a practicing civil law attorney for many years, I know how important restitution can be to make victims whole. So this is a fundamental function that we need to restore and make sure there's ample statutory authority. I want to end with a question to Chair Khan. We have the Blockchain Innovation Act that recently passed the House, going to the Senate, that would have you all do reports on cryptocurrency and the importance of consumer protections. Is that something that you all are prepared to be able to report on?
Thanks, Congressman. I think anytime we're, being given another slice of the economy to be looking at and studying, we want to make sure that we have the resources to be able to do that faithfully and discharge our statutory obligations. But certainly the commission was designed by Congress to be a watchdog across the economy and stay up to date on different economic trends and business practices. So, I think there's always a question about which regulator or which enforcement body is best positioned to oversee particular areas. So those types of considerations always need to be top of mind. But of course, if Congress asks us to do something, we're obliged to do so.
Sure. Thank you so much. And my time's expired.
Congresswoman Fletcher, you are recognized for 5 minutes. And I believe that's the last questioner.
Terrific. Well, thank you so much, Chairwoman Schakowsky. And thanks to you and Ranking Member Bilirakis for convening today's hearing. Thank you so much to our FTC commissioners here and virtually, and Chair Khan for the time that you have spent with us today. It has been a long day. I join my colleagues in apologizing for the interruptions, but this has been really important and useful information for us. So I appreciate you sticking with us and sharing your insights on the issues facing the agency and the country at this time. There's been a lot of useful discussion about how to modernize the consumer protection capabilities, how to address funding and resources and tools to protect consumers in what is clearly a complex and ever-changing marketplace. Mr. Soto was just talking about blockchain and his legislation related to that. There's so much coming at us so quickly right now. And I think, what is clear from this hearing is that you all need the resources and more resources to accomplish the many, many tasks we have put before you. In my district, we talk all the time about wanting government to be efficient, effective, and ethical. And certainly we know how effective the FTC can be and has been, but we need to make sure that we're giving you the resources and the tools that you need to be able to do that absolutely vital and effective work. And that was one of the reasons I was really glad to co-sponsor the legislation to restore the FTC's 13B authority and to see it pass the House. Like Mr. Soto, I was also a lawyer in private practice and know how important it is to have those remedies available to you. And so we're working very hard to continue to respond and move that forward as quickly as possible. I do want to take the about 3 minutes I have left to follow up on one issue, and then maybe, since I am the last person, put it out for any other questions or any other things that you didn't get to share. But Mr. McNerney was talking earlier about ransomware and other cyber-related attacks. And, in my home state of Texas, we saw just in 2019 alone, there were 22 different municipalities that were hit with ransomware attacks and really crippled core government services for days. Certainly the entire country was following as the Colonial Pipeline incident a couple of months ago. And we have really seen the challenges that these ransomware attacks present to people across every sector, whether it's, companies, schools, and local governments, hospitals, critical infrastructure. It really needs to be a concern to all of us. So, Chair Khan, can you explain the FTC's role in protecting consumers and small businesses, and really all businesses, against ransomware attacks? And then, rather than taking a break to answer the question, I'll also ask you to tell us whether the FTC has sufficient resources to follow up on all the ransomware complaints it receives, how more resources can be helpful, and any thoughts you may have on HR 4551 requiring reporting to Congress with kind of the time we have left.
Thanks so much, Congresswoman. I think it's difficult to overstate the importance of addressing head-on some of these really predatory practices and the kind of ransomware attacks that we've seen that have really crippled our critical infrastructure, as well as targeting businesses, both big and small. With regards to the FTC, we, of course, do use our unfair or deceptive acts or practices authority to scrutinize data security practices. And I think it's incumbent on us to make sure that companies are not being reckless and are really doing their due diligence when it comes to protecting consumers and protecting businesses from these types of attacks. I think there are also really interesting questions to be asked about the ways in which consolidation and concentration of data also render certain companies more susceptible to these types of attacks. It means that these types of attacks have cascading effects in terms of exposing millions and millions of consumers, millions and millions of businesses to these types of breaches. So I think both on the consumer protection side and also, frankly, on the competition side, we need to be thinking about how some of these incentives are working.
That's really helpful. And if I can just follow up on that with a question, and then I have a couple more questions that I'll submit for the record at the conclusion of the hearing. But there is a bill that's part of this hearing requiring the FTC to report to Congress on a recurring basis about cross-border incidents that involve ransomware and other cyber attacks, and to make recommendations both for legislation to us and also best practices. Does the FTC have the resources to do this, and does it have the information or have the ability to get the information that we're asking for?
Certainly, these types of information asymmetries are vast, and sometimes it is hugely burdensome on the agency to be able to do these types of regular follow-ups. So I think additional resources on that front are always very helpful.
Congresswoman, if I could just add with respect to ransomware attacks, and you mentioned being in Houston, an energy area. There's energy infrastructure is obviously Colonial Pipeline was a reminder of this, about how these are just unbelievable targets by state and non-state actors. In 2005, George W. Bush signed into law with a bipartisan majority in Congress the ability for the FTC to put in some data safeguards when it comes to energy and utilities. Commissioners of both parties declined to actually implement what Congress asked. So part of what we also have to do is look at all the authorities you've previously given us, see where they might solve some of the problems and ask for resources to actually do them. But we have to just stop ignoring these authorities that you're giving us.
Terrific. Thank you so much, Commissioner Chopra. I see I've gone over my time. I appreciate the chairwoman allowing me to get those complete answers. And again, I thank you all for your time today and for all the work you're doing on behalf of people across the country. Thank you so much, and I'll yield back.
Well, that does conclude our first panel. I know that you had planned to be here till 20 to 4 in the afternoon anyway. But I really want to thank you for your patience. It was this conclusion is a long time in coming, but thank you so much for those of you who are here. I include members that are here as well, online or in person, but especially the commissioners for being here, and we look forward. The subcommittee looks forward to working with you on many issues in a bipartisan way as time goes on. So thank you very, very much. Appreciate you.
Thank you, Madam Chair.
I'm going to...
Thank you so much.
Yeah. Okay.
We need a couple minutes.
Yeah, we're going to need just about 2 minutes or so to set up for our next panel, and I will then introduce them. Thank you.
Thank you, Madam Chair.